Item number 33, your Lordship. 33. On the matter, we are going to file our evidence in request. And the other side is.
I have for the respondent number 2, my lord.
Is this matter again on?
As per his seniority, may come up early.
3rd week of June. 3rd week of June. 24th of June 2026, allowing him to file the affidavit in reply to the response filed by the alleged complainant.
My lord, can it be on 25th?
25th, yes. 25th of June. 25th of June. Yes.
Much.
No, I get to mention I think about 20. But this letter may come up on 11th of June.
I'm appearing for the respondent Oil India Limited this matter. May come up well.
The request of the council of the petition, it is not objected to by the standing council oil. Place this matter again on
11th of June.
11th of June. 2026.
Obligation.
Yes.
Rejected the bail application also on the 29th.
May it please your Lordship. Lordship, with the consent of the other side, I beg to mention item number 24 of today's delivery.
24.
Lordship.
Yes.
Lordship, in this matter, some instructions are still awaited, which is why we're seeking for some time.
At the request of the Learned Standing Council for the Health Department of Vermont, with the consent of the Learned Council for the petition. Place this matter again on last week of 26th of June, allowing the respondents to file their affidavit in response. 28th. Yes. When do you want it? When do you want it?
Next.
At the request of the Learned Council for the petition, this matter again on 8th of June. Yes.
May it please, your Lordship. With the consent of the other side, Lordship, I beg to mention item number 17, Lordship.
17.
Yes, Lordship. We have received the records. If Lordship permits, we would like to file affidavit, bringing the record.
The request of the Learned Standing Council for the KAAC. List this matter again on
Next week, any date, Lordship.
10th of June,
10th, Lordship.
allowing the respondent to file their response.
Obliged, Lordship.
Item number 12, your Lordship. Item number 12, with the consent of the other parties, kindly accept the error for today. My senior is out of state.
Then why did you mention it for today?
Your Lordship, sir.
Why did you mention it for today? You have brought it by order.
No.
There must have been some emergency.
Because tomorrow is Eid. Kindly any other day.
After the although the matter was brought on list by making a mention, the Learned Council for the petitioner has sought for an accommodation today. Instead, accordingly list the matter again on 12th of June. 12th of June. Yes, sir.
My lord, item 39,
39.
a similar matter is pending before the division bench on 11/6/26.
There is a mediation
Master
report.
Torkar.
There is a mediation report. Failed. Mediation failed.
Yes, mediation failed, that is not possible. So, my lord, after 11/6, any that may kindly be fixed.
Learned, at the request of Mr. M.U. Mahmood, Learned Council, appearing for the petitioner, list this matter again on 15th of June.
Yes. Obliged. Hello.
Yes. Mr. Mohanto.
My lord.
In the earlier,
I-
Lakshmi has one.
I have appeared in this matter earlier.
That's daily back.
Eh?
That's daily back.
What does mean?
No. Lakshmi not there. But
Let us go one by one.
Yes, earlier of it, मतलब कि would observe is one letter regarding the मतलब
Earlier occasion, when the first writ petition was filed by Mr. Jagannath Dole, Mr. R. Muzumdar was heard and the matter was remanded back.
there right now.
Huh?
There right.
Am I correct? No. This name somehow stuck to my mind. Yesterday I went to the file. And I saw that my name was reflected in it.
But they otherwise मतलब the part. Ball is going
We
from
will,
one
we
foot
will,
to
we
another.
will, we will request the registry to have it listed on Monday next.
Monday.
Yes? Since they are with, all the three have to go. Tuesday,
Wednesday alone.
Wednesday.
No, but
Okay.
no, but I am not able to go.
Friday? Next Friday, fifth?
No. No, last weekend. Last week, I'll go the evening, no problem. On third,
You can go and make a request, have it listed any day you want to.
so on third.
I'll only say, list this matter before a bench without me.
I will answer.
There's no other way. I appear what to do.
ये मतलब lordship we came a lot of occasion for this court is claiming the same relief. Earlier occasions.
I have not even gone through the subject matter. I just saw the first two lines and I said, yes, sir.
It is seeking for a similar order, and they were appointed in 1961 as assistant teachers stipend officer. And they got some salary for 2 months. Thereafter, they were appointed as tutor, 21. Then they filed application for regularization. Similar cases have been filed here, my God, many cases. Page 178, my God, next key copies. Same order, only that year 90, instead of 93, 94, it should be 96 to 2001. And Bongaigaon, instead of Bongaigaon, it will be Stephen. Rest are same.
Bhumi also a Kalimgan, you know?
Yes. Instead of 93 and 94, it should be 96 to 2001.
Huh.
Many orders are there, have the next thing. The same.
Then we will have the name of the respondent as.
Education department.
Who appears for the finance? Mr. Cholia? I think their cases have been referred back for a reconsideration.
Yes, yes.
That would not be difficult. We'll pass the same order. We will take the order from page 178. The bit in the district and the name of the pending complaints. Otherwise, it will be disposed of. Sorry, the disposing the at the court you would write, keeping in view the nature of the order proposed to be passed in view of the submissions of the learned counsel appearing for the petition, learned senior counsel appearing for the petition, and the standing counsel for the department from a no formal notices are called for.
In the light of moral effect, my God.
Everything in that order, yes, both way, if you find anything to be referred or added or deleted, just let us know. Disposed. Yes, madam.
See, these matter pertains to pending areas alive. Amount of rupees 67,700. for a duration of 1/4/2016 to 28/2020.
When was the last proposal sent, madam? 2024. Your name?
Sita.
Heard Ms. G. Taludal and constantly paying for the petitioner also. Which department? Mr. H. Olihal and a consul appears for the respondent number one. One, stop. Who appears for the secondary education? Ms. D. Musahari, learned counsel appears as the standing counsel for the secondary education department. Claim of the petitioner is, in this petition is with regard to the area salaries amounting to rupees 67,711 for the period from 1/4/2016 to 28/2/2020. Full stop. The learned counsel for the petitioner had submitted that a proposal had been sent by the headmaster of the school in the year 2024 from Karimganj. However, along with a non-royal certificate. However, the respondents have not taken steps for payment of the area salary. Stop. Issue notice returnable 4 weeks. Since the respondents are represented by their respective counsel, no formal steps are called for. Full stop. Extra copies of the repetition to the learned counsel for the respondents within a period of 7 days from today. List again on 22nd of June 2026. No, we said 4 weeks, so we'll have to say 13th of July 2026, by which time the respondent shall inform the spot the steps taken for the payment of the admitted area salary to the function.
The petitioners were not done, their MA degrees could not be verified. Therefore, they left out a provisionalization. Particularly, these verifications were carried out. And there is a proposal, my lord, at page 63, my lord, where, my lord, their names were included for, my lord, provisionalization. That was in 23. But thereafter, this matter has, my lord, remained just like that, my lord. It's not proceeded further. In fact, on the similar cases have, my lord, fixed on, my lord, this first of, my lord, this next month. Where instructions have been sought for, my lord, matter will take fixed for instructions, man.
Heard Mr. N. Dr. Leonard, senior counsel, appearing with the assistance of for the petitioners. Full stop. Also heard the learned standing counsel for the higher education department and finance. Mr. D. Komenu for one and Mr. H. Oliha for the respondent number two. Two. 3 is not there. Will appear for 1, 3, 1, 3, 4, 5, 6.
Lordship,
Why not
in
the
that case,
principal?
Lordship, I am for 3, Lordship, in that case, because the serial number in my copy. I am for
You are
1.
not for 1.
I am for 1 and 3, Lordship.
1 and 3. Why not the principal?
No, notice will have to go, Lordship.
They are your provincialized colleges. Huh?
Usually,
You
Lordship,
want them to have their own councils
usually we don't accept notice on their
Okay.
behalf.
for 1 and 3. Mr. Soliha for respondent number 2. Steps on the respondent number 4, 5, 6, and 7 by usual process. Then how will you list it on the first of June? You respect that. You say, Mr. D. Upamanu, then the council appears, learned standing council appears for the respondent number 3, 1 and 3. Mr. H. Oliha for the respondent number 2, they have been submitted by Mr. Doctor that similar cases are slated to be listed on the 1st of June. One of them being WPC number. So and so, full stop. The petitioners shall serve extra copies of the petition on the councils appearing for the respondent number 1, 2, and 3 during the course of the day. Full stop. The learned counsel appearing to the higher education department shall have his instructions on the 1st of June regarding the progress of the cases of the petitioners for consideration for provincialization. Full stop, list on 1st June along with WPC numbers.
Highly.
Since the lawsuit, you should not discuss.
No, we have only said that they are representing, you give an extra copy, they'll have the
Yes.
instructions.
Obliged.
Because if we issue notice, then we'll have to keep it after 4 weeks.
Yes.
For some time, please.
My lord, after overruling of the judgment of Rangaya, my lord, the petitioner has limited its scope, my lord, in terms of the direction passed by the honorable division bench. Your lordship will find the direction at page 38, my lord. Because earlier the petitioner filed one petition that was dismissed, then he approached the division bench, my lord. He appeal, my lord, has observed in para 5, page 38, my lord. Then, because the contention of the petitioner was that, my lord, prior to the amendment, there were 2 posts, my lord. One post was filled up by the private respondent in the earlier petition. So one post remained, my lord. So the direction of the division bench was that according, however, since we have been informed that out of the aforesaid 2 posts of junior assistant, only 1 post has been filled up. The authorities in the cooperation department shall immediately undertake an exercise to fill up the remaining 1 post of junior assistant considering the candidature of the relative, along with other eligible candidates.
One word is missing there. You are not doing of that law. In accordance with law.
Yes, my lord.
The law says 1:4. You are at 5.
No, I am at,
2 posts, 9%. You are left out.
yes.
1 post filled up, 5% filled up. In fact, from the top now, if we against the other, he will also come. 4% to consider. You remember 1, 2, 3, 4. Against, 8% to consider against 2 posts. Yes, from 1 to 8.
Yes.
One of them gets seconded. Let us say serial number 1. Now the consideration for the second post will be based on the election. 2, 3, 4, 5 get the consideration. You are at 9.
I'm at 9, but my lord, they have considered up to 16 positions.
How? Who they have not?
Yes, my lord. So, because they have,
In the previous election days, you might have been at position number 16 or 20 or 30 or whatever.
yes,
The eligible candidates when taken out from that list, their serial numbers will change.
Yes.
Someone does not have PH, someone does not have PH, someone this, someone that, everybody goes up. So 9 candidates come into the poll. These are the 9% we need to consider for these 2 persons.
that,
You were at 9.
specifically, that has not been done, my
It
lord.
has been done in the order.
But in the process, my lord, that minutes I have annexed, my lord. In the minutes, my lord, they have taken the zone of consideration, 1:4, four posts, they have taken into consideration. Yes.
For 2 posts, there were 2 posts. Either you have list of the executive opposition, or we have list of the
Your lordship kindly peruse page 41, my lord.
page 45. I
41,
was at page 45.
41,
Page 41, yes.
41, the minutes, my lord, they have considered the last paragraph, my lord. 1:4, that is up to serial number 1 to 16, my lord.
There are 4 posts for filling absurd.
Yes, my lord.
Mr. Daluther, Madam, 4 posts. What 2 posts? Your affidavit says 2,
Two posts, my lord.
but then your mind will say 4, page 40. Why?
No, this is UD assistant.
4 posts of senior assistant and 4 posts of vacant, 4 number of vacant posts of junior assistant. What paragraph after the meeting? If it is 16, he gets a consideration.
The 2 posts that have been stated in the affidavit, it is in respect of the earlier round of selection.
My lord? Yes.
They were two posts in Islam because it was serial number 9.
Yes.
We agree to it. But the second minor was at age 40
Yes.
shows there were 4 more vacant posts of humans. So now it is 1:3. Now it will be 4:16. Yes. It was with serial number 9.
And the person at serial
One
number,
person got appointed. We come up with
and the person at serial number 16 has been selected.
No, my lord,
how can you consider?
no, my lord, yeah, I have stated, it was decided to fill up 2 posts.
Then why did the mandate super take into consideration both?
It took look post company earlier round to one way.
There are 2 rounds of selection as we understand it today.
Yes,
Yes.
these 2 posts that have been stated in the affidavit is in respect of the earlier round of selection.
Conducted it the year,
It was
but
conducted.
there are 2 rounds of selection in
Yes,
2 different years, yes?
Yes.
Give us the years of both of the selection, then Mr.
My lord,
Can that specific.
Yeah, my lord,
earlier-
page 42 makes it clear.
Okay.
Page 42 is the minutes, my lord.
What is
That is what we were doing.
Yes,
Type copy is page 40. Type copy to page 40.
Lordship will see, my lord, I am reading out the original one. Also, the committee observed the zone of consideration of grade 4 staff on the ratio 1:4, serial number 1 to 16 of the gradation list, and found that Sri Arup Jyoti Talukdar, Peonage Directorate, is only candidate who fulfill the criteria laid down under Rule 10(3) and 12(3) of the Assam Directorate Establishment Ministerial Rule 73 and amended Rule 2016 by notification so and so. He is a degree holder and has completed tenure of 11 years and 6 months. Committee also examined ACR of last 5 years of grade 4 staff and found satisfactory in his performance. Therefore, the committee decided to fill up 1 number of junior posts of this directorate by Aurobjyoti Talukdar. So others, my lord, were not found to have the graduation, educational qualification. He is a higher secondary pass. And that is admitted, my. And I have taken a stand in the year also, my lord. If your lordship comes to
Was
the,
he considered this? This is possible.
my lord,
42 was it in there?
My lord-
Take it up on Tuesday
yes, yes.
or Wednesday to your committee. Tell us whether his name was there in this 1:16 gradation list,
Whose name, my lord?
whether he was considered.
His name was not there, my lord.
Why not? Admittedly, he is at serial number 9 of the gradation list.
No. No, my lord. The zone of consideration, serial wise, my lord, I'll check it up. If he fits in also, my lord, he has to fulfill the other criteria with regard to
It
education.
will be for the selection committee to do,
Ah.
not for you to argue or not for.
No,
the-
selection committee has, that was,
That is what I am.
Yes.
Exactly what I'm saying.
Yes.
It was considered,
yes,
then not taken up,
yes, my lord.
then he was rejected is another thing.
Yes,
If his case was not even put forward,
my lord.
If his case was not put forward
Well.
by the concerned authority for which sponsors the name for promotion. And if there is a noting in the file that since he is not qualified, we are not forwarding it, even that will do. But was his name at all considered somewhere or not?
Only that much.
only that. His name considered rejected, we have nothing to say.
My lord.
In fact, we were thinking that this number will no longer exist in the pending list.
On the next day, my lord, I think
On
that,
Wednesday,
yes,
as a part of.
well,
Wednesday, as a part of matter, allowing Mr. Talukdar, given a standing counsel for the Cooperative Societies Department. You have his instructions as to whether the case of the petitioner was at all considered for promotions by the BPC held in the year 2021.
21. Obliged, my lord.
Good, brother. Third of June.
Pardon.
Sorry, my lord.
Yes, no.
Lord, petitioner was granted a great pay, my lord.
Hmm. The recovery part, huh?
They have sought to recover, my lord.
Yes.
There are similar matters which are pending, my lord. Around 7 matters are pending.
Mm.
I have annexed the order passed by a court may parents.
Heard Mr. Escon, learned counsel appealing for the petitioner, also heard Mr. D. Upamanu, learned counsel appealing for the Higher Education Department, and Mr. Choliha, learned counsel representing the Finance Department. Full stop. The grievance of the petitioners in this case is the attempted recovery of alleged excess pay granted to them on a wrong appreciation of the benefits of the Assam Revision of Pay Rules 2017. Stop. The learned counsel for the petitioner has drawn attention of this court to the order dated
Order dated, my lord, 27/2/2026, as page 124, my lord.
it passed in WPC number
1157 of 2026.
to submit that the petitioners are similarly situated and this matter can be taken along with the other matters for a proper adjudication. Full stop. The learned counsel for the respondents have not objected to the aforesaid proposition. Full stop. Accordingly, list this matter along with WPC number
1157 of
2026. Full stop. The interim orders governing the aforesaid petition shall also govern the present petition. Any date fixed on the other cases?
not June.
3rd of June. Since these matters will be listed again on the 3rd of June, notices are not issued at the moment. To facilitate their listing on the 3rd of June, full stop. However, the petitioner shall serve extra copies of the repetition upon the learned counsel appearing for the respondents to enable them to have their instructions in this matter also.
I took that.
What are the, I think in Russians, permission to just look into the order that is 6/2/26.
They were required to have your ACRs for these years 17 to 20 were not taken into account while considering you for
They are
promotion.
agree with their.
They have stated now. Some marks have to be given either an average or
Last.
whatever was the last has to be brought in here also. We'll have it after some time, maybe he's on legs somewhere. After some time, sir. It will be which or the other heavy. Scroll that. After some time. I can. Then.
Education department was directed to take some instructions. Regarding selection and appointment of clerkship.
2011 they started it, 17 last something happened thereafter nothing.
When PSC also wants some instruction also. Yeah, it is 54 also. Yes, wait.
8 nation.
10.
After some time they might be on legs. What would I say? Additional advocate generalism for item number 8.
This is 10 one.
We'll have it after some time. Let Mr. Chaudhary be here. Yes, Mr. Nayak, do you have any instructions?
Lordship, that is what I'm praying, Lordship. May I have it, Lordship, on Friday, Lordship? Because on last date, one of my colleague, commit for furnishing the instruction, Lordship, that we have not yet received.
You know what kind of an instruction is required?
Lordship, so far as the marking of the petitioner is concerned.
No,
that is not
what
yet-
happened is he was considered for promotion. There were no APRs from the year 2017 to 20. Therefore, no marks were given to him for those years. That is the allegation.
Yes,
Now, if the APRs are not there before the promotion committee or even before the sponsoring authority who sends them for promotion, It is his case that some marks have to be given, either an average of what has been given to
Sir, it
everybody, or what was my performance in the earlier years and what is my performance now. Do something you
Lordship,
cannot
under
give
the
zero.
rule, Lordship, it is his responsibility to furnish the APS.
No, he has to give the first page.
Yes.
He has to fill up the first page and give it. If the APRs are not available for 17, 18, 19, and 20, it was also the responsibility of the department to have informed him that you have not given us your APRs, because the APRs may be of a nature where his very service may be in problem. There might be complaints against him, there might be some very adverse remark against him, something.
Lordship, let this matter come on Friday.
Friday.
Fine.
Mr. Rochadri, we can have it on Friday? At the request of Mr. P. Nayak, Additional Advocate General, appearing for the respondent authorities, commands this matter again on 29th of May 2026 to have his instruction. এই নহয় মে শুকুৰবাৰে আজি পঠিয়াব লাগিব। Huh? What is the matter about? Sorry? Ah.
My lord, record is necessary, my lord, TP. We have filed affidavit, they have filed reply, otherwise ready. So fix.
Are you disputing any of the documents which are available in the writ petition?
No, no, my lord,
If not, matter goes back to the inquiry stage.
so that's why, my lord, the record is necessary.
Whatever is there in the in the writ petition, if you are not disputing the documents, the authenticity of it, then why should you go into all the records? If he had said that I have given a letter, you have not received it, you have given a letter, I have not received it, then maybe we'll call for the records.
My lord, this is, my lord.
We'll have it after some time, sir. Let us see. If the records are necessary, definitely we'll call for them. 2 years down the line, anything remains.
Hello?
2 years down the line, anything remains.
I'm not hesitating against the transfer as such. My limited prayer was that I was sent from Kolkata to Gauhati. This was a request transfer, so therefore I was not given any EAR joining time. But then within 68 days of joining at Gauhati, in public interest, I'm sent to Facebook. I initially state that it is a frequent transfer. So, but then that prayer has been abandoned. Then we put in a representative saying that if I was brought from Kolkata to Gauhati and then again put back to Facebook, you please consider my stay from Kolkata to Gauhati as a
Public
public
interest.
interest. Now the representation has been disposed of by a triptych order saying the authority has considered but then not flexible. No
But you have
justification.
got your transfer benefits from Gauhati to Tezpur. That you have got.
That I have.
What was your ground for seeking a transfer to Gauhati?
It was
Anywhere it's
for better education of the children. Some family issues were there. It was exited to there was no dispute. I was sent.
And you came here with your family?
Yeah.
And then you have to shift lock, stock and barrel to Tezpur. Who appeared?
All I want is a reconsideration that the way they have disposed of my.
Where is the disposal?
Annex 11 at face petition. Officer has been considered but not accepted. Exceeded by the computer not government. Say some not speaking order.
Had Mr. B. Pathak, counsel appearing for the petition. None appears for the respondents on call. You took too long. List again on Monday. On which date, even in the, if the respondents to unrepresented comma, the matter will be taken up for decision on merits. Is he in some personal difficulty? Huh? We'll have it on Monday. 1/4.
Yeah, some time they will seeking for some time lot, so we have not received the instruction much.
In 2 years, at least you have received the instructions. In 2 years, you have received the instructions.
File affidavit also.
Affidavit file.
No, we'll file also. Because of some communication gap, something.
Mr. Tohbilder, A.R. Tohbilder, Learned Council, appearing, Learned Standing Council, Director of Department of Higher Education has prayed for an accommodation of 2 weeks to file the affidavit in opposition. Full stop. List the matter again on 17th of June, 2026, by which time Mr. Tohbilder, Commander Learned Standing Council, shall ensure that the response to the petition is brought on record. Hmm? He is not praying for time. You start your argument.
Lordship, I pay for lordship some time, lordship, provide.
Same. What is this matter about?
Application of case. Yes.
Same order.
Same.
Yeah, go to the one before this. Same order, same.
He did make a fix. He did make a.
What date did you fix? 17th. 17th of June.
On 18th or 19th.
Hmm?
Many matters are there on the 16th, 17th. Also.
19th. You make it 19th of 19th of June.
16 lordship here, there are.
Ah,
In this matter, we have communicated with the college, how they have appointed, whether they have placed it before the district level committee or not, everything. So the response from college is awaited, and the college has also not appeared till now, lordship. On the last occasion on the lordship, their service was complete.
issue a suspension order to the principal.
Also,
Issue a suspension order to the principal for not responding to the director's requests. Everything will come. Don't take this in the
no, that's
line.
nice.
A request has been made on behalf of Mr. K. Miral and counsel for the petitioner for an accommodation for the day. Mr. Tohbilder, Learned Standing Council for the Higher Education, also seeks an accommodation for having instructions in the matter. Mr. List the matter again on the 22nd of June. 22nd of June. What is the matter about?
Claim the seniority lots.
Ah,
Yeah, Shan, I'll do some dates.
Affidavit file lots.
you have filed your affidavit.
Lots.
In opposition, you have filed your affidavit in opposition.
Lot.
Respondent number?
Respondent number lordship. 3 lots. On a 14/5/25 lots.
Should we take it up today after some time, or should we fix it for admission hearing on a hearing day? Have your instructions. After some time, we'll take it up. Hmm.
Maybe. Like, yeah, my love, before I proceed. There was a direction for it to filing. And we don't file them.
Also, we are not filing affidavit lawsuit. Earlier, two times this thing is rejected lawsuit, this petitioner approach, because they have suppressed the matter and we are not going to file affidavit lawsuit.
Then my lord, my case is my lord.
Hmm.
My lord, there was a, my lord, I must admit, my lord, that the petitioner approached Central Administrative Tribunal, my lord. And Central Administrative Tribunal did not start any order. As his original transfer certificate was for class 7, was found to be some discrepancy or fail. Now, whatever is available, that chapter is gone, my lord. My submission is that, my lord, the DRM, respondent 3, my lord, DRM, Divisional Railway Manager, respondent 3, my lord, have reviewed the earlier decision, and thereafter, my lord, he has called an inquiry, press inquiry into my eligibility of my certificate of acceptance on 11/2/11. Now, on the basis of that, my lord, page 38, my lord, he found that my past certificate, transfer certificate, my lord, is genuine. The headmaster also forwarded it to the respondent 3, my lord.
The one that we had earlier placed before the authorities, before the CAT dismissed your case, that was a fixed document,
Transfer certificate.
was fixed. Then you produced a fresh transfer certificate before the authority.
Did not produce.
Then,
I file an application, railway authorities respondent 3,
so who said it was fixed?
it was screening committee. Page
The discrepancy was,
screening committee, my lord, in 2007, say, page 20.
Hmm,
Screening committee told that your certificate, actually it's a transfer certificate, is found to be fake.
5th of July 2010, you were,
That was challenged.
just a minute.
Of July. Page 25.
What is this? I was misguided.
Yes.
We are still not, if you're trying to, we are going round and round. I don't know why.
My lord, that
There was one certificate which was submitted by you to the authorities that was found to be fake. It was a transfer certificate.
transfer.
Then you filed an application before the authorities saying that that class 8 certificate is
Yes.
wrong. It was a misguided certificate.
At that time, terrorist problem was, yes.
It was a misguided certificate.
Yes.
Then you said that I had appeared in the HSLC final examination and one certificate has been issued by the headmaster. This headmaster certificate is not the one which was produced before the authorities earlier. This is something new certificate. Now this certificate is found to be correct
Direct
by the department. And you say that now that I'm giving you the genuine certificates, please consider my case again. But the original certificate which you had given at the first time was a fake certificate.
Now, second time,
Now what do you want?
I want, my lord, as per the DRM inquiry, my lord. He has reviewed my status, and my all application are pending, my lord. My limited payable letting pass
That was in the year 2011.
11, it's pending, my lord.
And then 2011, and then thereafter, what did you do? From
Then, my lord,
2011 to 2017?
yes, I'm filing applications. My lord.
Mm.
Then, my lord,
Only thing, my lord, my humble submission, they are influenced by the earlier order of criminal. They are influenced by earlier rejection of my evidence. So they refer to that 2007 condition. So my thing is when the DRM has taken a fresh review of the entire decision and my certificate is found, nothing will pass a order, my lord, on the
Do you want them to pass an order? Do you want us to pass an order?
lordship may direct the respondent team.
We'll direct them to reject your case because of the delay from the date when the death occurred.
The time we are now looking into a case, we don't look into whether your certificates are genuine or not.
Your lordship, I have stated the facts clearly in my additional evidence. Page 60.
Overcome the particular.
I have
Lordship,
stated, my lord, that this certificate is conducted on the basis of inquiry conducted by DRM itself. And after finding it to be a genuine, DRM communicated to me that your certificate is genuine as per our press verification. Now, after that, my lord, my condition for appointment or consideration is pending. Then at last in 2022, Deputy Commissioner, my lord, in my read petition last annexure, Deputy Commissioner also, page 57,
Who is the deputy commissioner?
of the case, ABC. Page 57. Page 57 of my read. ABC wrote to the PRM to consider his case because, my lord, what happened, my lord? Something happened in the railway junction, my lord. Then I prevented the sabotage to happen. So this was also limelighted in newspapers and everything. And considering my conduct that you have prevented big sabotage and you have made those culprits arrested, DRM told that as per the earlier verification, if you can consider, just give it. That is the how, my lord, this everything came out again. So now, my lord, if they Apple can consider, my lord, considering a master circular is there, my lord. And one master circular,
Consider after this long period.
as per circular, they will consider.
Not on compassionate ground, because of your bravery, they want to give you something, you will not stop it. But why? Because of it.
No, as per the only, as per the report, my lord, they are inquiry, but let them pass.
You prevented a sabotage, you were involved in a sabotage.
Lordship, I have a judgment, Lordship, by Honorable Court, Lordship, that the same subject matter is dismissed by this court, Lordship. So kindly allow me to.
So my submission will be on this matter.
Approached earlier this court, Lordship. After tribunal's rejection, he has approached twice in this our High Court, Lordship.
The third time.
This is the third time, twice Honorable High Court Division has rejected his case.
I have brought them, I brought the affidavit. My submission on that is that, my lord, that your lordship will consider that facts was never been placed. These facts were never in the earlier case. Sub-silence, so my lord. The earlier, those decisions were challenging the court order, but this
You did not get this court that we had earlier litigation. You were sub-silence. You were silent on it.
that condition, my lord.
No.
Only limited prayer, your lordship may pass a order, my lord.
We give an observation that you feel bravery and everything, if they want to consider, the petition will not be a part, it will not be a direction to them.
Two times, get rejected two times, and the case order they have approached two times before this High Court was.
Get rejected two times.
Get rejected two times, they have approached two times.
On different ground, not on that. On their
That same set of, no, nothing was there. Nothing was there.
Page 73, my lord.
That part is,
Was the affidavit filed?
Affidavit filed, my April, my lord.
April 2026.
Yes.
that part was being before the Honorable Court when I have placed this judgment before this Honorable Court.
I have stated, my lord, these things are never been placed. The present writ petition facts, my lord, was earlier never been a part of the litigation.
Where is it saying, kindly consider my appointment on the compassionate ground?
Without, my lord, considering the revision, my lord, page 18, my lord. Considering the verification done by DRA, I am only limited to that.
Mr. Kogar, anything more? Anything more? No.
Only that limited there.
But Mr. Kogar, Yes, madam, you need
NN Sharma.
your standing counsel or on the panel?
No, on behalf of the resident.
On 17/12/1997, while serving the chief of the liquor at Odapur, Assam. You are the adopted son. The petitioner, who is the son of the deceased, and applied for compulsion appointment. And the medical examination of the petitioner was conducted in the year 2007 by the railway medical examiner. Thereafter, during the screening of the testimonial submitted by the petitioner, it was detected that the petition had submitted false dedication claim certificate. The petitioner thereafter approached the proceed from a Gauhati bench by going to a number 167, which came to the dismissal on 5/17/2010.
But page 29.
As per the contents of the petition. The petitioner filed a petition thereafter, being for a reconsideration of case by the divisional or by the review authorities by submitting that we could not procure the class 8 pass certificate at the relevant point of time due to disturbances in the Aplong area. And that now he was submitting fifth certificates for which his case can be reconsidered. With the case of the petition and the VRA, Lambing had conducted a verification process, and in the same process, the best certificate submitted by the petitioner had been found to be genuine. The case of the petitioner died sometime in the year 2023. We had been instrumental in apprehending miscreants trying to carry explosive devices in the railway, and therefore, when this such act of bravery had been noticed by the district authorities, a request has been made by the by the Deputy Commissioner Vijay Sampadev Nagar to the railway authorities to process, to examine the application of the petitioner for appointment on the compulsory ground again, and to submit a report to the district authorities. The counsel for the petitioner submitted that the aforesaid grounds, the case of the petitioner requires to be reconsidered by the railway authorities without reference to the earlier dismissal of his original application by the learned tribunal or the learned tribunal. Miss Sharma, the council of paying for the respondent 14 that
on earlier occasions, it was pointed out, pointed out to the school that there had been some suppression of the effects by the petitioner and the petitioner. In the record, the order became.
Division bench order actually is clause 7/8/2012 also. 7/8/2012 also.
The order dated 7/8/2012 was in WPC number 255 of 2012. The subject that the order of the unit tribunal carried up in appeal before the intelligence of this court, which appeal in the form of the petition had been dismissed. The comfort for the petition for the respondent to thereafter refers to the order dated 2018 passed in WPC number 598/2018, by which the OA, which again referred to OA number 167 of 2010. Was there another way?
Loss.
Huh?
Loss. Second time.
This WPC of 2018, it was a reference to which OA? Any OA number you have?
16.
Oh, that is the first OA.
First OL also. After that also he has approached the authority also, just like it or when.
At which, now you write, she has also drawn our attention to the order that was passed in the PPC number 594/2018, by which the prayer of the petitioner to have the matter reconsidered at the hand of the respondents that been rejected by this court, observing that the same petition was dismissed, short of imposing costs.
Then also after that also he has approached the cap lawsuit in 2020 lawsuit, OA number 257 of 2020 lawsuit. 257 of 2020. That was also dismissed on 4/12/2020 by cap lawsuit.
Will counsel for the respondent further submitted to the court that with by the petition on similar prayers have been rejected on 4/12/2020. That the petitioner had supposed all these legal facts in the petition, and therefore the petition that is spot. So she has further submitted that in light of the people who are spot in the official. But what is that?
State of West Bengal versus Devabata Tiwari.
Devabata Tiwari. Is what I did?
Well, then I'll give myself some meaning, so many important.
Reported so usually long elapse of time between the date of the death of the employee and if there will be the consideration of not being
Scheme was constructed. Under scheme, it was some direction. If scheme is there, some direction maybe.
the case doesn't require any further consideration by the The counsel for the petitioner in response has submitted for that. And additional affidavit has been filed. Now, additional affidavit said being filed by the petitioner to bring on record the order dated 2665, order dated 7/2012, passed by the court in the PPC number 254/2012, and also the order dated 59/2018, passed in the PPC number 592/2018.
We however find that the petitioner. However, they keep some information. The proceedings of OA number 257 of the 87 of 2024, the authorization. 420 will be passed. Passed on the. The first round of litigation from our. The petitioner had. Submitted. And effective. Second number of litigation. It would divert each other. And for. It is apparent that the consideration is earlier for the past. The petition finding the was dismissed. There is. That is conceived. Which both of the thing itself. In the present matter, we again find the petition that was. Of the. The Johnson. Or that the same was dismissed. So. Council with the petition submitted that it is on the act of delivery. For which the. District authority with the state of Assam have requested the DRF. The review authority should also the brief of the petition. That the petition has. Again, it will score. Consider. Looking to this petition. This has reached very important. They itself from increasing the petition of the proceeding. The same for the petition. That we need only before one program but in different forums. Which both brings the religion for the people for directly the respondent for the people for the form of the down. Okay. This put is once again with
maybe kept open. Earlier verification process 11 to 2007.
that in case the that
The case of the petitioner has also been forwarded by the district court for consideration. For appointment due to the act of bravery of the petitioner in diverted. And I apprehend experience on the page. It's both for the corrections comment on the same, save and accept. We observe that this is a, this litigation was with regard to the consideration of the case, on the basis of completion of which court of provisions on the alleged on the act of bravery displayed by the petitioner. We will not be very big. Why is nothing advised for to come up with the this case could have been a simple one. I paid for a compassion appointment, I was denied. Yeah. Now I have done an act of bravery. Please consider it. Simple and clear.
Earlier, verification was never please. And you also misguided by.
Verification report regarding some other certificate.
Yes, but
Then
that was never in the paper.
let us not dwell into that, we might make up the mind to impose costs. Another issue.
All right, sir.
First, we discuss the finance department has filed their affidavit, the department has yet to file their affidavit.
Lordship, Mr. N.J. Khatungya will be appearing in this matter. He's on legs in court
You
number
will be
one.
drafting the affidavit in opposition
no,
here, has he drafted it or is he
No,
filing
that's
it
not
within a week? Just tell us.
Lordship,
Okay, then shorten me kindly.
Without the affidavit, can we proceed?
No, no, no.
Mr. Khatungya?
No.
Kindly tell us if you are very, if you are paying for time, do it now.
Lordship. Lordship will file our affidavit. We have,
The petitioners are assistant teachers who had acquired graduate degree during the post. Now they are claiming the pay scale of graduate teachers. Yes, Lord.
Indian bench judgment, let us finish it now.
Lordship, that
Vinod,
we have stated that in our affidavit.
Vinodini Singh.
Lordship,
It's a sin, na.
Lordship,
Can you overcome that? Lordship,
page
can
164,
you
Lordship.
overcome page
164 of our affidavit, Lordship.
164 of the affidavit?
That is the,
You are insert all Assam amalgamated secondary education. And that was in service, state qualified. English in and another one was there.
yes, Lordship. Vinodini Singh, writ appeal 155 of 22. Lordship.
That was regarding secondary.
Yes, Lordship.
So
Also, I am not the engaged counsel in this case.
you are not the engaged counsel.
Not the engaged.
Otherwise, facts of the cases are that. Lordship.
When?
Also, it may kindly fix up for in the first week of
First week of June. Give us a date. Give us a date. Choose a date. You are not the engaged counsel. Choose a date. Mr. H. Alia, learned counsel appearing for the finance department, has submitted that the facts of the case are squarely covered by the earlier judgments passed by the division bench of this court with regard to similar claims made. Full stop. Learned counsel for the petitioner has prayed for an accommodation to address the court on their behalf. List the matter again on 4th of June. On which date an attempt will be made to dispose of the matter if the same is covered by the earlier judgments of this court.
May I please your motion? Lordship, can I please that matter may be taken at 2 p.m.
What is the matter about?
Lordship, I have said it speechless to submit to the honorable court.
Mm.
I couldn't mark it, your Lordship.
No, we just want to know the topic.
But this is the service material, Lordship,
a correction of date of birth also.
not date of birth, your Lordship, the date of superannuation.
Let's make kindly see the prayer.
Lordship, kindly may be taken at 2 p.m. your Lordship. I have just. some
Mr.
case-
Nair, you can give her 1.5 hours.
Only submission will be lordship. We have already filed our affidavit in
Yes.
this matter, but they have not yet, I think, filed their reply.
No, they are.
Uh,
If
I
they are
think
not
some
intending.
of the documents, if I remember correctly, some of the documents reflect the date of birth to be 1969.
Yes, sir.
Two
One
documents.
document.
Two
shows it to
two
be
major
19
documents.
Huh.
One is the regularization order.
Hmm.
Your lordship, may kindly see in my affidavit, lordship. Page
Income
40,
tax department, we are not interested.
page 42.
page 22, before the.
Page 42 of the affidavit, Lordship.
42.
This is the typed copy, Lordship. Original is the next one. Lordship, may kindly see his date of joining is 91 and date of retirement is 2025. And if Lordship comes to the service book, Lordship. Service book, Lordship, at page 44.
Page 44.
Lordship, may kindly see the date of birth. 44. Date of birth in the middle portion, 11/4/1969, but it is overwriting from 65 to it has become 969. And Lordship, may also see the date of retirement, 34/2025, which was now somebody wrote it as 2029. So nobody has.
Can he have access to his service book? Service book, he would not, he would have access
But
to
this
the
is
copy.
ultimately this is manipulation. No, without authority, somebody corrected it, whoever it may be. Somebody corrected it. Corrected means
We
over.
we are not on, we are not only on that, we'll allow her to have her judgments also. We are acquainted with the law that at the last stage you cannot come down and have, ask for correction of date and all that. We understand that part of it.
But the fact remains
But
that
there may be certain,
our prayer is for correction of the date of birth.
you would perhaps not bind us down by saying that we cannot modify the prayer to the extent.
FRSR and the settle law.
The government of Assam, this ID card
The ID card and the.
at page 21 was something issued from your end.
Not ID card is not the, I mean, the authority.
It records as 11/11/69.
Lordship.
It is a very relevant.
Keeping all that in view, if a inquiry can be conducted into the original birth certificate and how the manipulation came up.
In my submission, Lordship would have a certain direction, Lordship. If he would have come before the authority prior to 3 years of retirement.
Okay.
PML
That part we'll take up a tube. We'll dispose it this way or that way. Okay.
Make me done. Oh, if it is not been filed since September.
Yes, Lordship, I have to apologize, Lordship. In
No.
this case, we are yet to file our.
By when can you do it, Mr.
Lordship will grant it 3 weeks time, Lordship.
Our date will be there. Interim continues till then. Mr. P. Nayak, Learned Additional Advocate General, appearing for the respondent department, has prayed for an accommodation for 3 weeks, assuring that the affidavit in opposition would be filed before the next date of listing, full stop. Accordingly, list this matter again on the 26th of June. 26th June,
Lordship.
2026, by which date the respondents shall ensure that the affidavit is filed. Full stop. The interim orders passed earlier shall continue.
Lord, sometime may be granted to file affidavit in opposition. Yes, so that my lord, immediately after vacation, my lord, positively will file my.
You are discharged on what? You are not getting any pension till now? You had completed your 10 years of service?
Disability pension. Because I, during my training, I got. During training, my.
But, madam, there is a judgment on which she relies. At page 24, there is a judgment on which she relies of the division bench. Matter relates to pension
ma'am,
from the year 2025.
10/1/2022, sir. Yes, sir.
That says that the person would be entitled to disability pension within a period of.
Then, my lord, kindly take it in midweek of June, my lord. I'll go through it.
What was the defect found on him? Unless it is alcoholism.
Yes.
What is it? Ah, stress fracture and fracture medial malleolus. Can you say it is not arising out of service? During battle physical efficiency test, what more do you need? When were you appointed?
When 2002.
2002 to 2023, 20 years he has anyway served.
But she is in
For case 20, my lord. My review medical was done in 2024.
Ah,
Till today, they have.
then madam. He is in training madam, at the time of this
how
discharge.
can
madam.
it be? Appointment letter, which is, your name is Samudra Kolita.
Yes.
Samudra Kolita, what is this? Seeing, madam. What is annexure 17? Annexure 1?
Validated from the service on 31st of October 2003, my lord.
Ah. Then he joins back. You allow him to join back.
Yes, my lord.
During training, the leg is gone.
Yes, my lord. My lord, meeting of June, my lord. I'll take instruction.
At the request of Ms. E. and Standing Council, Learned CGC, appearing for the respondents list this matter again on the 22nd of June 2026. Full stop. The Learned Council shall have instructions regarding the applicability of the order dated 10/1/2022 passed in WA 332 of 2021 to the facts of the present case also. Full stop. The respondents should be at liberty to file their affidavit in opposition in the meantime. Full stop. It is made clear that the matter relates to the grant of disability pension, where the petitioner alleges that he was disabled during the training being conducted by the respondent authorities. Full stop.
Same, side. 26.
Same one.
Same.
Okay, okay.
Petitioner seeking universal seniority, but
This matter, can we take it up on a hearing this? You have filed your affidavit, your reply is filed. What about the private respondents?
I know some have appeared, some have not appeared.
None appears today. Very good.
Yes, appeared lots. My friends.
You are appearing for whom, sir?
4, 6, 9, and 10.
Why were you not here when the matter was called?
Report number.
You were there, not in court number.
No, shift. At this moment. Yes.
You are appearing for?
4, 6, 9, and 10.
Have the others been served?
I know it has been served, man. I know my currently payments of this code 20, 10, 25.
28, 10, 25.
Sorry, my lord, 9, 5, 25.
9, 5.
5, 25. This one. So, that it has been delivered to respondent 7, 8, 11, 12, and 30. Was not appeared.
7, 8, and 11.
7, 8, 11, 12, and
11, 12. And who else? 7, 8, and 11. Where is 13? 13 also, sorry. Any orders of this court that the service is going to be complete?
perhaps not, my lord. 5, my lord, I will ask him.
The office note dated. It was the date you told us? 9/5/2025 reflects that the respondent number 7, 8, and 11 had been served. 7, 8, 11, 12, and 13 had been served. Full stop. Accordingly, the notice on the aforesaid respondents is deemed complete. None appears for the aforesaid respondents today. Full stop. Yes, you see.
My lord, respondent 5 I have served Dusty.
Respondent number 5 has been served to Dusty, and none appears for the said respondent also. The petitioner has submitted that the affidavit in opposition by the state respondents have been filed in the matter. And he has also filed an affidavit in reply. Full stop. No affidavit has been filed by the respondents represented in the court, namely the respondent number. Yes, tell us. 4619.
6, 9, and 10.
You don't want to file anything?
No, sir, ours then is good.
The Learned Counsel appearing for the respondents, respondent number 4, 6, 9, and 10 submit that their stand would be covered by the affidavit filed by the state, and they would not be filing any other affidavit in the matter. In view of the aforesaid, list this matter again on the 25th of June for hearing, since the pleadings appear to be complete. Full stop. However, the unrepresented respondents would be at liberty to file their affidavits, if any, on or before 11th of June 2026, and the petitioner would be at liberty to file the reply to any affidavit filed by the unrepresented respondents on or before the next list.
Obliged.
25, 26 capacity. এই হেরিয়ে যে করলো এস বড়া huh? I was somewhere involved.
Reduction of pay, honestly.
My lord. He does not want us to take up the matter. Leave this matter before.
I don't want to be biased.
He doesn't want to be biased. We can be biased. He does not want to be biased.
Much of that. I thought, can we have a look at the order 8/4/26?
8/4, yes.
Yes.
Only what?
It's 31st of May, I'm going to return. Possibly, instead of the matter, my events may be kept open after retirement, in fact, then the line also paying. Then after retirement, we all, there is, whatever the national promotion regarding that benefit is concerned, the lordship kept open that, lordship exposed of this matter. Because may not during pendency, may not this order, may not, I'm going to retire, may not this month, may not.
But if they are not taking up any promotion, any process for promotion prior to your retirement, if they are not taking up any promotion, can we say that even after retirement?
My given said that at the time,
No, no, sir, look at this. Certain person, if an incumbent is expecting a promotion. Yes, he retires, no promotion process is held.
during pendency.
During pendency of the writ petition, he retires, no promotion process is held.
Yes, Lord.
Now, 2 years thereafter, the department says that we want a promotional process. Can he still be considered?
Then that means supposedly on which date I was eligible for the promotion, my lord. That
It
is
could be, there would be so many persons eligible for promotions.
Yes, my lord. Had it been considered in right time, I would have get that benefit, my lord.
But
That is
then
clear,
I
my
don't
lord.
think the law supports you on that.
My lord, already there is the apex court decision in
Saying
the
that,
some Supreme Court decisions,
Ah.
my lord, also decided on this point also, my lord, that if a authority failed to provide that benefit during this period of tenure of service, my lord, in the meantime, if he got retirement, my lord, then he cannot be given benefits, my lord. So my right is also involved in this matter, my lord. So then, if they are sitting silent about a matter, by that time I'm going to retire. Since for the last before my retirement, I am actually in my ground, my lord. I am praying this normal court also granted this interim protection to me, my lord. But unfortunately, this 31st I'm going to retire, my lord.
you came in too late. You came in 2026, what to do? What to do? 1989 list you wanted to be?
Yes, my lord, only there.
Yes, the others came in the others came in 2013. They got an order in 2024.
Basically, my lord, lordship will find by annexure 14, my lord, page 80, my lord, they club both the 88 to 91 all together, my lord. Surprisingly, my lord, they segregated only for the 88, 90. Why not the 89, 91, my lord?
When was that? When was that list
Yes,
published?
yes. My lord, that earlier, my lord, annexure 14, page 80.
When was the list published?
Earlier, my lord. Annexure 14, page 80.
Yes, sir. Who appears for this forest department?
It's tonight court has recorded this order, the order they have placed, court is not satisfied, there is 10 million.
Which order?
8426, some.
Oh, this is done in persons of Kukhol Kumar Deka,
Yes. That's
Monday. I was
the,
appearing in Kukhol Kumar Deka.
we got the interim today is still returning to the interim, that may be completed.
When I'm not taking up the matter, can I continue it?
It's also true, my lord.
Hmm?
It's true.
Have it listed on Monday?
Monday, my lord?
Hmm?
Yes, my lord.
List the matter before a bench without me. Listed. Now list the matter before a bench without me on 29th of May 2026, since urgency.
I was not, my lord, 29 before my determined 31st May.
29th, I've said 29th.
Yes, 29.
29th of May, since urgency has been expressed.
Suppose.
I'll come back in 2 minutes.
Your lordship, I raise a maintainability issue of this petition, lordship. Because they have not made the nodal agency as a party respondent. Because in further lordship, they have not even given what marks they have secured.
Lordship,
They have,
subject matter of this case is similar to WPC 903. And similar order,
maintainability issue was there also.
but they haven't filed the affidavit yet.
On the ground of then I will file.
Petitions together. Lordship. And on the last occasions, on the last occasion, we had also indicated that any other parts in this petition cannot be fulfilled. Lordship. The petitioner should keep on. Lordship. Will be kept on wait. I will. I've also a simple increment of the respondents would solve the entire problem. Yes. We have the marks and everything you will bring on record. Lordship. Whether they have stated or not, you would bring it on record. Lordship. But the directions have to go to the nodal agency. Lordship. That much we agree to. You are the SSC. SSC. Lordship. And where is the advertisement? Advertisement is at page 19. And page 20, it was clearly mentioned that the CRPF is the nodal agency. The last occasion we just pointed out by the court also, but they are not. What is your grievance? Non-inclusion of their names in the final merit list. So who makes the final merit list? Final merit list makes after giving, so for the CAPFs, then SSC makes. So SSC. You made the final select list. You tell us why the names are not there. Because the nodal agencies were not recommended his name. But without that can be brought on record that the names were not sponsored by the nodal agency. Not therefore the names did not reflect. Therefore I ask why your can we ask him, can we do in that event, in the absence of the nodal agency, Lordship, none will be there to answer the particular query and it will be dismissed. Lordship. But then unless you bring it on record, Lordship, saying that yes, the nodal agency did not Lordship supply us the Lordship names, and therefore we could not. Lordship. The next question, there will be no one to answer. Lordship. What is to be done? Lordship, I will file it within 2 weeks, Lordship. Think it over again, madam. Today we have made it more clear. Someone has to send the names to the SSC for them to consider you on the merit list. Once they say, we did not get the names.
Because we have qualified every.
Very true. They were not given the names by the persons who were required to send the names. Who was that person? Who was the person who was supposed to send the names? Who? Not a party. No answer. And whether no read. Think it over. An implement petition could perhaps solve it. Whether the petitioners are qualified also, this was not there. Then you will bring on your list to Lordship for the last qualification. Lordship. Then we will say that we do not know what the petitioners are. Lordship. Lordship. It's waiting for a dismissal. Lordship. After 2 weeks, Lordship. List again on the 17th of June. Lordship. Along with WPC number. That. What is
903.
903 or 203. No black.
From the matter relates to Milord, we had been selected pursuant to an advertisement and after participation in a fair and a very transparent selection process for the purpose of sponsoring us for the veterinary field assistant training course. Now, Milord, when the select list has already been published and notified in newspapers also, Milord, suddenly we have come to know that the new council, that the PTC council which is coming to power, has Milord decided to not give effect to the said selection. Now, the minutes which they have prepared, Milord, I have made a part of the Milord in my petition. My Lordship may be pleased to find that minutes, Milord. Is that page, Milord, starts at page
73.
My Lord, 73, Milord. The last part, Milord, clause 5 says animal husbandry and the veterinary department. The inquiry report of the chairman of the inquiry in connection with examining the legality of the selection process towards filling up of
71 numbers of the veterinary field assistant under the animal husbandry and the veterinary department, BTC was discussed. BTC decided to cancel the selected candidates for admission to 1-year veterinary field assistant course in elementary knowledge of the so-and-so veterinary science at the school veterinary department, Ungul, Silchar, Assam, as the selection process of the GFA was conducted in deviation of the acts and rules of the government of Assam. The EC also instructed the department to plot new advertisement for admission to the 1-year veterinary field assistant course as per the guideline of the government of Assam in the greater interest of the public. Now, my lord, I have made a search. There is no any such, my lord, guideline or the statutory rules is governing for the purpose of, my lord, conducting this veterinary field assistant training. Now, recently, my lord, they have filed an affidavit in opposition, my lord. From that affidavit in opposition, I could come to know, my lord, that they are following a rules. My lord, they have termed the rule as, I think that affidavit.
Page 82.
My lord, if my lord may be pleased to take up the page, my lord, 83. Para 9, para 10, that the deponent states that be it stated that the acts and rules of the government of Assam may be adopted by the Bodoland Territorial Council with such modifications as may be decided by the Honorable Executive Council of BTC. Insofar as the appointment to the grade 3 and grade 4 posts are concerned under the Animal Husbandry and the Veterinary Department BTC, the Bodoland Territorial Council has adopted the recruitment rules. My lord, may kindly note the recruitment rules of the government of Assam, namely the Assam Animal Husbandry and the Veterinary Subordinate Service Rules 2002, which govern the recruitment procedure for appointment to the post of veterinary field assistant. In this regard, so and so speaks for itself. Now, my lord, our case is not recruitment. Our case is for sending a person to the veterinary field assistant training. After completion of the training, this rule will come into play for our appointment. So this is a purely an arbitrary, my lord, and act and.
Yes,
and-
what is the inquiry report?
Lordship, the inquiry report starts at page 88, Lordship, of our affidavit.
Yes, my lord, they have make a part of this report. Same thing has been reiterated.
This is pre-recruitment.
If Lordship comes to page 89, Lordship, our second paragraph,
Pre-recruitment.
Lordship.
Ah,
It is seen from the records that the BDC issued instruction for second paragraph, Lordship, for selection of candidates for the aforesaid.
where is the advertisement?
My lord, in my
Advertisement is at the reputation page.
petition notice at page 50, my lord, next one. Undergoing, my lord, EFF training course. Procedure has also been, my lord, notified at page 51.
Animal husbandry rules, do you have that?
My lord, that's the rules I have regards, my lord. Service manual.
Do you have a copy of the rules, sir?
So I apologize, Lordship, but don't have it.
It is not available in the net? No. You are representing the BTC or the animal husbandry?
Lordship, the BTC, Lordship.
BTC, who represents GA Assam?
So I am put a respondent number.
Who is the respondent number one?
Commissioner and Secretary.
Huh.
Name is given.
But Mr. A. Abhinay Leonard, Senior Counsel, appearing with the assistance of
S. Laskar.
S. Loskar, Leonard Counsel for the petitioner. Full stop. You are appearing for?
Lordship, respondent number 2, 3, 4, and 5, Lordship.
Naam to person? Your name?
And R. Sharma.
N.R. Sharma. Mr. N.R. Sharma represents the BTC.
DJ on behalf of the case.
Here's for the respondent number one. Full stop. The case of the petition in this petition is that after having participated in a selection process for undergoing the VFA training course in elementary knowledge of animal husbandry and veterinary science at the School of Veterinary Science and Animal Husbandry at Silchar, the petitioners' names were included in the final select list to undergo the training. Full stop. The advertisement was issued by the Office of the Director, Animal Husbandry and Veterinary Department in pursuance of the approval of the BTC Council afforded by the letter dated 5th of August 2022. The Senior Counsel for the petitioner has submitted that the selection procedure had been conducted in accordance with law. However, by an order, by a resolution adopted in the resolution adopted in the minutes of the meeting of the BTC held on 22nd of December 2025, the Executive Council had decided to cancel the selected candidates and had instructed the department to float a new advertisement for admission to one-year veterinary field assistant course as per the guidelines of the government of Assam. The affidavit of opposition filed by the respondent number 2 and 3 is to the effect that the selection process was not conducted in accordance with the Assam Animal Husbandry and Veterinary Subordinate Service Rules 2002, and therefore the cancellation of the selection was called for. Full stop. The respondent number 1, namely the Secretary of the Government of Assam, Animal Husbandry and Veterinary Department, shall file an affidavit stating the relevant guidelines of the Government of Assam for admission to one-year veterinary field assistant course, and shall also place before this court, along with the affidavit, a copy of the what rules?
That animal husbandry, veterinary.
So-and-so rules 2002 as amended in 2017. No, along with the amendments of 2017 as notified in the official gazette. List the matter again on 24th of June 2026.
My lord, one thing I forget to bring into my lordship, kind notice, my lord, that page 74 annexure 11 is an advertisement
Lot issued by the Director of Animal Husbandry and Veterinary Department, Sanikuti, for the other part of the reason, my lord. Same procedure had been adopted. There is no written examination have been notified by the state of Assam, not by the BDC.
Okay.
My lord.
The
That's my kind of-
senior counsel has submitted that although a stand has been taken in the affidavit in opposition, that the absence of a written examination was one of the cause for one of the reasons for cancelling the selection process, he has, no, the advertisement dated 11th of June 2025 issued by the government of Assam also does not require the holding of a written examination, and therefore the grounds given in the affidavit in opposition may not be wholly correct. এটু আপনি উপর লিখে দিব। তারপর লিখিব in such circumstances the respondent number 1 shall file an affidavit.
Sir, may I prefer fixed date? Because
We have fixed a date, have we not?
24 June.
24 June.
my lord. Declare.
Madam Patesh Kumar and non-payment of my area salary, we might suspend the period. In the meantime, my lord, I have already get what pension claims, pension rating of the equity. Family benefit of equity, only my this payment is pending. My lord, the police authority already forwarded to the lodge. Take this number 40.
What was the order of this court?
Lordship.
And what happened to the disciplinary proceeding?
Supreme proceeding, my lord. My lord,
Any disciplinary
No,
proceeding
no.
against you?
no,
Lordship, I have not received any instruction in this matter.
I will allow the repetition.
Verify.
Will allow it.
Lordship, instruction I'll have to get.
When?
2 weeks, Lordship.
2 weeks.
so my lord, kindly see the page number 30 also. There was less than my lord, thereafter my lord, I was. One line, my lord.
You are required to complete your instructions by Bihu.
Yes, Lordship.
It is done.
2 weeks, Lordship, I'll get my instruction.
Mr. D. Commanuel and a council looking for the Director of Higher Education has paid for an accommodation of 3 weeks to have his instructions completed, full stop. The petitioner has, in this petition, has paid for the arrears salary for the period under which she was kept under suspension.
27/8.
That is from
To 27/8/2019 to 5/10/2021. Amounting to rupees 16 lakhs.
the petitioner had been. What was the, you were arrested?
Yes,
I was arrested.
The petitioner had been arrested on certain allegations. And the suspension was a result. Was arrested and had been forwarded to judicial custody, full stop. The Director of Higher Education had placed the petitioner under suspension pending trial of departmental proceeding, full stop. Tell us one thing, once you are placed under suspension before your retirement, does not the discipline, does it not fall under that part where the discipline proceeding can continue?
But there is no, my lord, kindly see the page.
Then she was reinstated.
It is still also. Kindly see my lord, page number 30, my lord, why I was.
Why?
In the, my lord, paragraph 3 was. The served note against the Miss Ada Torres, so and so, so and so, so and so. This misappropriation of fund money of the society, also. Namely, so and so, function under the Assam Cooperative Society Act. The society is not under jurisdiction of the director. Meaning there, my lord, there is no question of recovery also. We committed in other departments, but you in my department.
You committed.
For that, lordship, I have already faced my criminal person.
What was the room with 20? place this matter again on the huh? 22nd of June, by which date the Learned Council for the Higher Education Department shall invariably revise instructions on the entitlement of the petitioner or pay for the suspension period. It is submitted by the Learned Council for the petitioner that no department proceedings have been initiated against the petitioner, and in fact, the allegation on which he was taken into custody is also not related to either a case of moral turpitude or one related to her official duties.
Right.
Yeah, but I'm paying for a little accommodation for today, madam. Any date next week, madam.
What was the cause? But you have not completed the selection process. You are not giving them the instructions.
That, madam, I have been told, madam, that the rule has been framed and it is in the legislative department. So I'm
Now,
not.
do these vacancies, this selection process has started under the old rules.
Yes, madam.
Does it continue under the old rules or the new rules?
That is why, madam, I have not no any written instruction today.
Just a discussion on law. Once you start the selection process by asking them to give the advertisement, they call in for the applications, everything done.
Yes, yes.
They just want a clarification that what is the education qualification that we should look for. Yes?
Before that, when the prayer which was made by this honorable, made by this petitioner before this honorable court, your lordship kindly see the prayer, my lord. The prayer that, my lord, as per then. Your lordship kindly see. To fill up the vacant post of assistant inspector of school under the education department under the in completing the process of initiating the advertisement dated 17/11/2011 by the division bench, my lord, this was disallowed. This prayer was made by the state, my lord, before the after the division bench judgment they filed in this case. We may be allowed to proceed with the advertisement. So that was rejected. So since that rejection order is there, then, my lord, how government can
Is it on record?
Yes, my lord, in our affidavit.
You have not
Page
answered that.
52.
That advertisement is not there, Lordship.
You have not answered that, sir.
No, page 52, your lordship kindly see.
17/11/2011.
This is of 2011, Lordship. This is of advertisement is of 2011, Lordship.
Yes. And
Lordship, then
what is your advertisement?
Lordship,
Your advertisement is dated?
Lordship, 2011. And
Please
it
come to
continued,
page,
Lordship.
please come to page 53, page 52. Do you have the affidavit filed by the APSC, sir?
Lordship.
Yes, page 52.
Lordship.
That miscase was preferred by the government, my lord, state of Assam. Had I number so and so, which is an application permission to allow the state respondent to fill up the 16 number of post assistant inspector of school pursuant to the advertised selection process initiated by the advertisement at 17/11/2011. Selection process of initiating apparently not in a conformity to the order dated so and so, so and so. The pair made in the application therefore cannot be allowed. So meaning thereby.
The lead petition closed with the liberty to.
That's until this order goes.
I will verify with this is the IA order, Lordship. In case I have to go to Lordship. One day, Lordship, Friday.
At the request of Mr. Bhagavati, Learned Council appealing for the petition, list the matter again on Friday. 29 of May.
My lord. So long that order stand, my lord, they cannot proceed.
I have missed it. I will go.
Mr. Mohanto has come to the rescue of Mr. Khatoni.
I just.
I just feel great today.
It will
May I please, Lordship?
Yes.
Pass about a time being, Lordship. So senior council election route number 21, Lordship.
Any urgency today? Any urgency today?
Lordship urgency, since your lordship is service that has been terminated, your lordship. In fact, your lordship, there are.
Oh, that one, police constable.
Lordship, and your lordship, if your lordship go through the inquiry report, your lordship,
Why should-
this is completely perverse, sir.
Why should we go through the inquiry report at all, sir?
Lordship. No, here your lordship, in inquiry report, your lordship will find that I myself is an witness, your lordship.
Eh?
Yes, your lordship. And
Your name is?
Yasuddin Laskar. They have examined me as PW, and there is, even assuming that this inquiry report is procedure adopted by them is correct, your lordship. Even going by that, this finding itself is perverse, your lordship. No material at all. No one has.
Come to
incriminated-
page 46.
Lordship. That is there, your lordship, page 46. That will also punishment has been given, and then your lordship second proposed notice.
State Council.
Not sir.
Can you take page 46?
Not sir, I have seen not sir.
Second paragraph,
Not sir.
third line from the top. In view of the above, do you find it?
Not sir.
You are hereby dismissed from service.
Dismiss from service
Huh?
on the ground of
You are giving him the inquiry report and you are hereby dismissed from service. Beautifully done. Now, when he then kindly come to one aspect which had caught the attention of this court. Page 51. Madam, I am willing to prefer an appeal. You find that paragraph, second paragraph from the top? What is he asking for?
Appeal.
What is he asking for? Copy of what?
Inquiry report submitted.
And in second show notice does not say that we are giving you the inquiry report at all.
I have made a statement. But
Yes. F2 for disposal. We will not go into this appreciation of evidence. Kindly have your esteemed counsel prepared. When does the show cause notice, second show cause notice fall? Whether the copy of inquiry report is required and whether a man can be make a witness against himself or in the
for
in
first,
his own inquiry.
Lord,
In an inquiry that is.
first one, your lordship, ECIL is there.
Huh?
ECIL is there.
Three judgments just give us the correct paragraph.
Lord.
We will dispose it of a fee. Unless they dispute the documents that he has attached. He was praying for time to have the records.
Not.
It will only be when there is a dispute with the documents. Yes. Next. Yes, sir. Hmm?
One money. By a PDP license, and PS might be.
Are you agreeable to adjust the NPS?
No, no.
How? Hmm.
Who is liable to receive this? Amount?
Hmm?
Who
You?
is liable to receive this amount? Because bond is signed in a number 4 for TME. I filed this litigation for respondent number 1.
Who is respondent number 1?
Commissioner Secretary.
You have signed a bond with the government.
Undertaking is also
Which
there.
presented by the DLE.
TME. Khanapara. And the petition is submitted before the respondent number 1. Whether the bond is in their hand or not, total process may be under observation of court of agreed.
Each process.
If I deposit this money, they should have to give my, with any acknowledgement. And they, after receipt this, they can send it to
Promotional secretary, and he received my resignation. Resignation is just not one in dispute, and my bond is in the Kanapara law. So there,
Your case is that even if you deposit the money, they may not allow you to resign. Yes? Deposit the money with the
now
appropriate.
I resigned, but they do not accept.
It will not be accepted unless you give the.
There is no clause in the bond,
Saying what?
resignation or transfer.
What does the bond say? That he will serve.
Yes,
If he does
10
not serve, he will
years.
pay the money.
Yes.
Pay the money, go. The moment you pay the money to the coffers of the state, we will direct that. Once the money is transferred, they will not insist on your continuing in the service. They will release you.
Yes.
They will release you from service the moment they get your money. Pay the bond money, they'll let you go.
So I can pay.
Are you attending your duties now or are you not attending your duties now?
With 3 months time.
Are you attending your duties now or are you not attending your duties now? You are not attending your duties now. Are you getting your salaries?
No.
You are not getting your salaries. Why didn't you dismiss him from service and then get the bond executed?
He has already filed an affidavit of undertaking to pay the money before 19/12/24, Lordship, which is page number 66, Lordship, as per order dated 18/9/24, Lordship.
Where is that bond? Bond copy?
Sure, Lordship.
Is it available on recording the petition?
No, Lordship. It was directed to,
Be produced.
yeah. Plus 4, Lordship. Point number 4. Huh? बोलता नहीं सोचा बच्चे को नहीं बोला
You are dismissing the petition. You invoke that bond, you go for a money suit. File a money suit against him. That is what the bond says.
Yes.
What is your prayer? Have you considered his transfer? Yes, madam. Have you considered his transfer?
In the bond, there is no provision for
No,
transfer.
forget
No.
the bond part. Just
No.
on a usual administrative side, someone is paying for a transfer. Can it be considered, accepted, rejected, whatever?
Like this case, there is no provision for transfer.
No, he is serving you. He's a government servant under you, is it not? Where is that letter? Appointment letter? Your place of posting? Where is your place of posting?
Page 80.
Page
80.
18.
Joining letters. What years computer? Fortunately, it is a very.
Kindly see page 17, madam.
Yes.
Page 17. Which is your name? Number 2. At page 17, serial number 2.
Yes.
His place of posting was at Doboka CHC Nagaon. He was posted to Hailakandi CH,
Place of posting on
PP Center,
transfer.
Hailakandi. Huh?
Place of posting on transfer, Hailakandi.
Hailakandi. So kindly have your instructions. Kindly have your instructions. If he can be considered for a transfer to the appropriate place.
Yes.
He has filed this petition in the year 2018.
18.
He has not served in Hailakandi. He has not served in Doboka. By taking cue of this,
A specialist. And he the gynecologist. In Hailakandi, but there is no any petition, just.
no, your case was that your father is not keeping well and therefore you cannot go and join. If there is no place, if they want to use you as a compounder there, go and serve as a compounder there. It is for the government to decide what they want to use you as. Don't give us that story.
Thing is
What
that
kind
he
of a
has signed
job
a
you can
bond, Lord,
execute
under the
will be
bond.
determined by the government. Degrees do not show what a man can do in the office. Yes,
He is still under the bond, Lord.
he under the bond, you can recover it by a money suit.
Mm.
He does not have to pay you anything. He can run away, you file a money suit against him.
Yes.
Is it not? We were not going to that extent, but that is what the bond says. So either you file a money suit or you consider his transfer, accommodate him, you get job done. Refuse it, you invoke the conditions of the bond. Matter ends. First dismiss him for unauthorized absence. Dismiss him from service. Because he did not serve you for 10 years. Invoke the bond. But he is not serving you for the last 8 years because there is a repetition pending.
13 years.
You have not served for 13 years. Very good. He has not served for 13 years because of a repetition. Yes, from 2016, he was transferred in 2016. This is 2026. The health department is simply we'll have it at 2.
Direct the authority also.
We'll have it at 2. Kindly have the additional AG here, Mr. Gogoi. At 2.
Your lordship, it's relates to your lordship whether and Israel Arts Masters in Israel Arts and.
Lordship, yeah, I received some instruction, Lordship. No place again.
They have filed an.
Can you override all the others that we were taken through yesterday?
No, Lordship.
No.
In fact, Lordship, I kindly pay paragraph 2 and 3. And affidavit in this regard was also filed today. No, I will conclude. Today we have filed this affidavit stating.
Tell us, when are you having that meeting with the different
8
Gauhati University and who are the other academic institutions?
8/6/2026, Lordship.
8/6. You are having a meeting on 8/6.
In fact, Lordship,
on 10/6.
Lordship.
We will 15/6. For my satisfaction. I have given you a lot of NCT guidelines.
We are convinced that it is one in the six plots. Plots. We had convinced her yesterday that it is not one in the plots. Plots. We had fixed it today because there was one matter which is from the plots, where part of the subject was in plots. They are now holding meetings. Plots.
In fact, Lordship, Department of School Education came to know only in the month of April 2026. Lordship, may kindly see the read petition. There was no, the department.
2023.
26.
From 2023, the entire selection is kept on hold.
No,
Your
Lordship.
department does not know why it has been kept on hold.
No, the entire proceeding was not kept on hold. Only the petitioner's issue was.
There was an order from the court regarding one post.
appeared in my lord is really written on it. And in fact, my lord, there are shortage of my lord candidate also. Some poster lines, the hand poster line, there are no candidate.
Yes, we'll have it on the 15th of June.
Lordship.
We keep a copy of this.
Lordship, and in fact, I have already filed a affidavit today stating this development.
T.N. Sharma, Leonard Council, appearing for the Education Department, has submitted that an affidavit has been filed by the respondent Education Department.
Lordship.
He has also placed before this court the instructions issued to him on 26/5/2026, which are to the following effect, from this one. From this.
On the basis of this instruction only, I have filed.
Para 3 logo. No, para 2 or para 3. Let the court will. So, accordingly, lists matter again on the 15th of June, on which date the department shall inform this court the outcome of the discussions taken place. Full stop. This court observes that on 25/5/2026, the Learned Council for the petitioner had placed before this court several communications and notifications and clarifications issued by competent educational authorities, whereby it was apparent that the degree of the master's degree in a master's degree in fine arts was equivalent to a master's degree in
Visual arts.
Visual arts. Full stop. We are having it on the 15th of June.
As a partner. Since your lordship has already.
We have not heard on merits. We are only awaiting their instruction as to what they want to say. But otherwise, admittedly, it is highly declared. Then they would say that you are not the expert. User expertise should be there in every UGC and NCT, everywhere it is. Obligate. Take the obligation. Yes.
Ma'am, please. The last occasion, my lord, they need to have take instruction, my lord, whether benefits have been given or not. Whether my benefits, my lord, I got already Richard. And my entitlement, lordship will see at page 27.
Lordship, here, Lordship, we are on the verge of complying, Lordship, because GIS has already been paid to the petitioner. Yes, Lordship, I have, Lordship. The petitioner has also been called to submit certain documents, Lordship. Arrear salary will be paid, Lordship, subject to budget. The budget session is going on. So department is basically asking for one month's time, Lordship, because
That said that there was some deep admissibility report to be obtained.
that Lordship, that part we have not received from the AG, because of which only regarding the leave admissibility part, we are following up, Lordship. For that also, that will be paid. I've been assured by the department within 1 month, Lordship, because for the pension, we have already sent to the treasury officer. I'll just provide my learned senior, Lordship. Sometime I have.
Let me give you one copy.
Yes, I'm just giving him the copy. Here we have mentioned, Lordship, where at all the process, at which stage we are. The respondents, Lordship.
Mr. Surya submits that the GIS amount for the petition and for the.
Yes, Lordship.
And processes on to pay the area salary if any and the leave encashment benefit. For which,
And pension also.
for which the certificate. Leave admissibility report from the AG office is needed. The student councillors for the submitted the pension to the.
Forwarded to the treasury.
The treasury, sir.
Yes, Lordship.
To initiate the pension of the.
Lordship.
Submitted to the elected administration, which plans to the.
Lordship.
Is this matter again on the 26th of June?
Lordship, yes.
Yes, paid for 1 month.
Lordship, Lordship may fix it in July because June also, Lordship, we can give an update on that day. Lordship.
15th of July.
Left.
On the 15th of July. By which time it is.
Yes, the compliance report.
Completely by. the
Lordship.
Then ensure complete compliance of you.
Lordship. Obliged.
This also kind of long payment of ideas, right?
Yes, area lordship, we have communicated with the lordship, the department, the directorate has communicated in January that we entitled for amount.
He has told you in January.
January, but
That project is good.
no, lordship, thereafter that's government has returned the file to the directorate lordship for some anomalies in the head of the account. So we have received that only recently only. Lordship. Some time in the record because already process has started.
We cannot ask them to give you checks from their personal accounts, but the process is on a month more. July 15th.
We'll do that process under process.
2026. The process is from 6 of 2026. And I think now 5/26. March gone. But once the financial year goes, there has to be a fresh proposal. So the fresh proposal you have started sometime in April. There was a mistake in the head of the company.
Yes.
So now it has been corrected. Can you require one more? The builder and partially for the respondents submitted that the process for payment of the area select the petitioner is under process. And in fact, the proposal has been submitted by the director to the government. However, someone noticing a mistake in the
Head of,
account, the same has to be rectified.
yes,
In
sometime.
the meantime, the financial year has also lapsed. The concept for the petition, respondent has submitted that will be taken up in the month of July, by which time the respondent shall endeavor to ensure full compliance of the orders.
There was no.
WBCO. Shall endeavor to pay the entitled amount of a year's salary to the petition.
Lots.
Accordingly, with this matter again on the 15th of July.
15th.
2026.
Obliged that.
Right. Thank you. So with that, don't come up with the January again on July, or something new. That's now I get us something new on the next week. Hey, July will, January will take you till July, half the year. Something in July will take you to December.
Because we can't back.
Yes, sir.
There are a number of private funds always serving in the PRP class. 24 is 2 of the persons, number 17 and 24. When the pay is the order is 22 to 24. 17 and 24, they were on deputation. We were directed to take steps upon them. They were on deputation and so we had divided. That was taken, but that return answered with the remarks no person found. That is what according to the Lawajama Court's order. Now, thereafter, the Lawajama Court asked us to take appropriate instruction that we can see presented. Currently, what we have done.
we taken the appropriate address and we took steps for service. That was number on the last version of phase two, guidance and action. Now let's check. Respondent number 24.
You are speaking of the note dated 35 or the order dated 13/5/2026.
Right. Respondent number 24 has returned from deputation. That is my instruction and is currently posted in circular. That respondent number 17 is still on the board.
No, you have to 13/5/2026 says that the post title has to be amended. Yes.
Otherwise,
Have
address.
you read the 13/5/2026? Then put in an application, have the, it allow that, allow you to file an amended post title. Take steps accordingly. Because the repetition will have one address. They will be served in some other address.
We have taken this one is 24. Because in that was the 26 to 24. Court had directed us to take steps upon the appropriate action. Taken.
It did not go.
It did not go that. Return answer.
No, it returned unserved. Why?
But it with the remarks, no person found. When your lordship will find in the Lavasana post order. That is number 21/4/2020. 21/4/2020.
What do you want to do now? The present addresses that you know, the correct addresses. Will they receive notice on that addresses or no?
The respondent number 24 will take steps with the respondent number 2 because he has returned from the. That can be taken to the respondent number 2.
You move an application telling us that these are the addresses where we want to take these steps. Then a counsel for the petitioner has prayed for an accommodation to move appropriate application to furnish the correct addresses before this correct addresses and pray for an amendment to the cost title of the petition. Accommodation is granted till accommodation is granted, matter be listed with the interlocutory application proposed to be filed by the petitioners. Anywhere you file it, will take it.
Right.
Epic.
Will kindly come to page 33 in this offers. First of paper. May I read it? We are hereby asked to show cause under section 65 of Assam Police Act 2007-6. Going to completely why? If analysis prescribed your process will not be inflicted upon you on the following charges based on the document for evidence. While you were attached to Bankusmara OP on 7/2023 at night, local public Vilaypur area created human crime front of the discussion gate and accusation that Vilaypur PS staff have allowed to pass 6 numbers of illegal garments superloaded Tata Intra connected by taking rupees 60,000, 10,000 from each vehicle. In this regard, Inspector will be Joysankar Warif, PI, Tata, and OCI, Kala, interrogated Chief Constable Babu Sinha, who was detained for patrolling some Naka checking duty at that place about the release made by the public tendency. Chief Constable Babu Sinha confessed his bill of accepting rupees 25,000 as his share out rupees 60,000 from the began staff. He also stated that driver HPI of Losport rupees 3,000 as his share and rest amount were taken by the vendor. Further, he stated that he returned the cash amount of rupees 60,000 to the second entry SI on the Vinit Singh and the veteran. Further, he stated
negotiated the deal for passing the above mentioned vehicle with the second OC Bilasipara police station. Head Constable Babu Sinha also revealed that only you can identify the owners of the Bombay Supari loaded Tata DI, Tata Inter vehicle. On the other hand, you reach Vilaipur PS from your present place of posting in Banduk, Kamra, OP without any prior permission of the competent authority, and you negotiated the deal for passing the illegal Barney Supari loaded vehicle. This is not, this is an act of misconduct and within the 16 Act of duty on your part, which is not acceptable from a member of the secret uniform force. And based on this, your lordship. Now, first, your lordship will kindly see the first paragraph. It seems, your lordship, they have already made up their mind that the punishment will have to be given to me. Then, your lordship, statement of allegation at page 34. The same allegation. Essentially, allegation is that, your lordship, I negotiated the deal. There are two allegations. Lordship. There are two allegations. And secondly, your lordship, that I came without permission from the authority. Now I reply, your lordship, page 35, 36, your lordship. My reply, I have specifically stated that what has happened, your lordship, that what I have stated, your lordship, has in fact corroborated by the witnesses, your lordship. Then, your lordship, inquiry proceedings started, your lordship. Page 39 is the appointment of inquiry officer. One Surajit Chaudhary APS and as the inquiry officer, which is for a result. Now, page 40 is the inquiry. First part, your lordship, narration of the what is there in the so-called notice. Your lordship may kindly come to page 41, your lordship. There are 9 listed witnesses, your lordship. Now, at page 33, your lordship will get 9. Now they have examined 11, your lordship. 1 additional witness as well as the petitioner. So your lordship will kindly come to. This is the person, your lordship, Joyce Party, your lordship, who has conducted a preliminary inquiry. Now his statement is purely based on the statement of, he claims to be the Babul Sinha. Your lordship may kindly come to the last part of his statement. Thereafter, on being asked, Head Constable Babul Sinha confessed that he took money from Barney's super loaded vehicles to be so and so. He also said that he passed the vehicle as UBC 38 Gyasuddin Loskar, the petitioner, told him that we already have talked with PS staff to pass the vehicle. As such, he allowed the vehicle to pass, as he has also seen Gyasuddin Loskar was in the PS at the daytime. Now, your lordship, interestingly, your lordship, these questions were put to me, your lordship. I was cross-examined. After taking evidence of PW1, your lordship will find, have you talked with PS staff passing the Barney's super loaded vehicle? Answer, no. Have you told Head Constable Babul Sinha for passing the Barney's loaded vehicle? Answer, no. This kind of, your lordship, proceeding unheard of. Is this asked to the petitioner or to the PW? To me, your lordship, by the inquiry officer. But your lordship, this Babul Sinha, your lordship. Wait. Yes, have you told Babul Sinha for passing the Barney's loaded vehicle? This is specifically allegation against me. No, this should be a sentence. The question put to Jason for Bari also. Yes, your lordship, should have been put to be me, your lordship. It is not. It was put to me. And that is why this question, whether I have asked him or not, Babu. Now, the second witness, he does not know anything, your lordship. His second witness says page 42, he does not know anything about the reason for which DP has been drawn up against so and so. Now, third witness says, your lordship, Abhijit Sinha, your lordship, your lordship, that he stated that he was posted at Bilaspur PS from December so and so to December. Mr. Kotaku, lordship. If you are saying these are the questions between you, lordship, we will need the records. Lordship. Now, your lordship, even if your lordship, it is, if we give it up, then your lordship will kindly see. No, the question that will fall is,
if it is set aside from the inquiry report sheet, Lordship, then you'll be given a copy of the inquiry report, Lord, will be, Lord, you will have your answer to it. If this inquiry proceeding goes because the inquiry officer called there, then the inquiry has to be read, Lordship. So it will go one stage prior to the inquiry report. Therefore, if you are questioning this part, the inquiry officers
pointed out.
no, that is also the page 42. The statement by Babul Sinha, Ghiyasuddin met him and asked him, how are you? He replied that he is fine. Then the next question, have he met Babul Sinha at so and so? Yes, and asked, how are you? So apparently this is a question to the petition.
Lordship.
Mr.
And your
Senior
lordship,
counsel was correct.
you know,
With the records.
your lordship will kindly see the statement of Babul Sinha, your lordship, for a moment. Your lordship. The main accused, your lordship. He stated that on 7/2/2023, along with two personnel so and so of Bilaspur were detailed patrolling come Nakaseki duty for 10 p.m. to 6 a.m. On next day, on 7/2/2023 at around 8 p.m. he was seeing UPC Ghiyasuddin Law School at Bilasipara PS and talking to SI Abhijit Singh. UPC Sukesh Chandra Das of Bilaspur PS. During his duty hours, UPC Ghiyasuddin Law School met him around 10:30 p.m. and asked him that the army's battle not loaded vehicle are going or not. Then he replied that no. Again, the early morning of so and so and around 3:30 a.m. UPC Ghiyasuddin Lockport met with him, asked how are he, and he replied that he is fine. This is the only, your lordship, incriminating material in the entire evidence against me, your lordship. That to your lordship, that I negotiated everything. Nothing has come out from the evidences, your lordship. Even we accept this evidences, your lordship. And apart from that, your lordship will find that there is a, just for a second, your lordship may kindly come to the statement of PW 11 at page 43. This is the additional witness, your lordship, not listed witness. Now, what he said, your lordship, that without permission, I have visited the place, your lordship, higher authority, PW 11. Now, PW 10 is me, your lordship. He stated that he has been posted at Bandukmara OP since first week of January 2023, and SI Armbands Noor Ahmad Borgoy was the IC of Bandukmara OP on 7/2/2023. SI Noor Ahmed Borgoy was on EL, and on that day at around 11:30 a.m. UBC Ghiyasuddin Law School reported him for giving permission for proceeding to Silchar for his wife treatment. Accordingly, he permitted to UBC Ghiyasuddin Law Court for his wife's treatment. Then officer in charge Hailakandi PS was in charge of Bandukmara OP during the period of SI Nur Ahmad Burma, but he did not inform OC Hailakandi PS about the matter. Next morning, he returned to Bandukmara OP. Now, your lordship, that I have taken permission and went to hospital along with my wife. That has come out from their evidence itself, your lord. That is why I am submitting that, even assuming it to be correct, then also it is perverse, your lordship, finding. And your lordship will kindly analyze this next 44, your lordship, page number. And there is a finding, your lordship. During inquiry of I observed that on 7/2/2023 around 12 when UBC Ghiyasuddin Lockport was received an information from his wife over phone that his wife is suffering from pain. So the delinquent seek permission from so and so. Accordingly, Samarjit Day permitted with him instruction to return next day morning. That's, your lordship, the finding of the inquiry officer itself, your lordship. In the midst of this page 44, your lord, in the middle.
As per our permission, he went to his house in Bilasipur.
During, your lordship will find during inquiry. at the middle there. I observed that.
During the inquiry of mine.
Because during inquiry of mine,
Hmm.
I observed that on so and so at around so and so, Gauhati offer was received.
Yes.
These are his findings, and suddenly at page 45, during inquiry of the DP, the delinquent so and so asked to produce defense witness records, if any, with him for his defense in connection with DP number so and so drawn up against him. On 15/7/2000, he appeared before me and stated in this regard he has no defense witness. And he stated that he has been submitted some documents attached to this record reply. After careful examination of all the statements of the prosecution witness, the delinquent and additional witness as well as the available reports in DP5, the charge with misconduct and disseminate act of duty against the delinquent, he has been law for all his part is proved beyond reasonable. Suddenly he has reached this conclusion also. The finding must be, your lordship, followed, logically followed from the analysis of the evidences. Where is that logical reasoning, your lordship, in the inquiry? And then your lordship has pointed out already in 46, your lordship, they have already said that punishment is given, then I have been asked to submit representation. Now, from the beginning to end, your lordship, and your lordship judgment is there, your lordship. I just want to rely on that. That from the when SOCOS was issued, your lordship, they have in their mind of the disciplinary authority that I have committed the offense. That is there, and that is why your lordship inquiry report has also been submitted in such a manner, prepared in such a manner, your lordship, that somehow I will have to be held guilty, your lordship. At every stage, your lordship, there is violation of, and your lordship does with your lordship may kindly go. Para 25. This is not going to be. I Para 25. Para 25. Para 25. The second SOCOS. Gross on that. The SOCOS notice issued to the petitioner on 13/12/2023 now regarded whether look by this court. It is revealed therefore that the disciplinary authority has already made up his mind regarding the guilt of the petitioner and has already framed the mind that the petitioner was liable for punishment. And then one judgment, your lordship. This is from our High Court, your lordship. Honorable Justice A.K. Goswami, your lordship. 27, your lordship. That, your lordship, prior to completion of the evidences of the prosecution witnesses, your lordship, I cannot be examined. Your lordship, para 27, just the line, your lordship. For the purpose of this case, it is not necessary this court to determine whether the petitioner has suffered prejudice for not furnishing in the inquiry report for the purpose of showing cause in his state, because there is a fundamental flaw in the conduct of the proceeding. Perusal of the records reveal that the statement of the petitioner was recorded on 12/10/2001. Evidence of the prosecution witnesses continued till 17/6/2002. Mr. Sinha has submitted that only after the statement of the petitioner was recorded, the evidence of the prosecution witness was started. Though it is difficult to say whether it is actually correct from the proceeding of the inquiry, at least one aspect is apparent that the statement of the petitioner was recorded before the evidence of the prosecution witnesses was closed. Further record of the proceeding does not disclose that petitioner was asked as to whether he would like to examine any witness in his defense. The inquiry report is silent on this rule 9(6) of rule so. Then your lordship, ultimately this proceeding was your lordship order of termination was interfered with by this court. And last line of this paragraph, your lordship, examination of the petitioner before evidence of prosecution was closed is also a serious infirmity. This para 27 last line. So in view of all this, on the ground of perversity, on the ground of your lordship, that procedural lapse on the part of the respondent authority, your lordship, this order, your lordship. And on enquiry report, your lordship, ECIL is there. We do not know whether the enquiry report was served upon you. No, your lordship, that was not your lordship. Your lordship may kindly see the second so-called notice. The second so-called notice must disclose that it was enclosed with this, your lordship. Second notice does not disclose that. Your lordship may kindly come to para 16 of my writ petition.
Huh?
Para 16 of my writ.
Have you said that?
Para 15. That the petitioner begs to state that after serving the order of dismissal to the petitioner was sought as because he was never served with the inquiry report as well as statement of witnesses. Accordingly, petitioner submitted a PR petition insurance before the superintendent of police seeking the inquiry report as well as the relevant documents of the proceeding. And with regard to that paragraph, your lordship, in para 3, they say in affidavit in opposition, has no comments, your lordship. Can't be selected. Therefore, in every counts, your lordship, this proceeding goes forward.
Yes, sir.
My lord, regarding page 44, last part, my lord. Thereafter, he moved the seal shore, accompanied his wife, while the delinquent UBC 38 Gauhati Law School was returning from RE nursing home Silsor to his house at Bailapur over his wife's car at around 10:30 p.m. on where he met with a party, Babul Sinha and others. Then he did not talk with anybody about illegal passing of Burmese Supari. Next day, early morning on 8/2/2023 at around 4 a.m., he was returning to his place of posting again. He met with the duty party and then also he did not ask anything about illegal passing of Burmese Supari. He returned to his place of posting at Bandukamara OP in the morning 8/2/2023 at around 7 a.m. During my inquiry, it is learned that the statement from Inspector Joy Shankar Wari, Eden CI Lala that UBC Gauhati might be involved passing of Burmese betel-nut loaded trucks at Bilaipur PS area on the night 7/2/2023, where a UBC Gauhati Law School visited the Bilaipur PS and met with the PS staff. And on the night, 6 numbers of betel-nut loaded trucks passed the Bilasipura PS area. Further inquiry, it is found that the delinquent Gauhati Law School left his place of posting in Bandumara OP without permission from the superior authority. So he's dealing with the staffs and concealing about the passing of Burmese truck It admittedly, my lord says, my lord, he has a nexus with the parties. He met the parties, duties parties. So on with the duty parties, my lord, he has a nexus with them, and then he, without permission of the superior, he left the, my lord, this police station. Why? Without any permission? Why he came to it? He sought permission to move Silsor to a treatment of his wife. But during that period, he met with the staff of the where talk is going on. Nakasaki is there.
Where do we find that he was meeting with this star?
My lord.
Where do we find that he was meeting with this star?
Oh, yes, not last.
Thereafter, he moved for Silchar, accompanied his wife. While the delinquent was returning to his house at Bilaipur, he met duty party.
Yeah.
And he did not talk with anybody about illegal passing of permits. He did not talk.
Did not talk.
Next day, early morning, while he was returning, he again met with the duty party.
Yes.
And then also he did not ask anything about passing of permits super.
Why
He did not talk, he did not ask.
He did not ask, did not talk. That means he was involved really. If he says that he will be Malot, that is the question, Malot.
Okay. Yes.
And now, so far inquiry is concerned, Malot, so far first, so cause is concerned, allegation, so it's okay. And the inquiry, Malot, regarding his cross-examination, allegation of cross-examination and defense witness, he denied it.
The person who had given you the leave is good and attend your wife and come back. That person was that has been given by Somojit PW11.
Yes.
Now the disciplinary authority at the inquiry officer holds that he has left the permit. From whose state?
But
when the person giving the permission or the person who had allowed it is saying that I have permitted. Permission may be rightly given, wrongly given, with an application, without an application.
Viable permission.
But private permission he has given. So who is at fault? The person who gave the permission. A person under command of a senior officer, if he says, please go, he will leave. He will not assume that it is an illegal permission because any person who disobeys the lawful command will also be subjected to disciplinary proceeding. So he is asked to leave to attend to his wife. He leaves. So the second allegation at least is not proved. But the disciplinary authority and the inquiry authority without inquiry officer without any application of mine says second is also proved. Appellate authority says second is proved. So there is no application of mine.
That is a ballot, they have going through the inquiry report on the basis of that appeal also rejected.
Inquiry officer comes to a specific finding that PW11 says I have given permission. Therefore, the charge that he left with the permission is proved.
That was okay. He was given permission to leave it. But during the when he moved to the
other witnesses are saying he did not talk.
That means why he will talk? Because he was involved in this matter.
Should he talk?
That's what he did not talk, Balot.
Yes.
So, Balot, it is a Balot, it is preponderance of probability of charges, Balot. So, it is not a criminal.
We are trying to differentiate whether it is preponderance of probability or
of charges, Balot. And he cannot be Balot proved like a criminal case, Balot. So, his involvement is Balot confirmed by the inquiry officer. That is the case, Madam.
Now, kindly come to the first show cause notice.
Page 33.
You are asked to show cause as to why any of the penalties should not be inflicted upon you. He's not saying why we should not give guilty. He's saying why I should not penalize. The frame of mind that you are guilty is already there.
So, Malat, whatever, and Malat, this writing of languages and others are from defined from officer to officer. I have seen it.
Now, if we have
Like it is not a fatal Malat, but he was asked to show cause.
Then the second show cause notice,
Second show cause notice, my lord.
46, you are hereby
I
dismissed.
have seen, my lord.
That has to be.
That's why, my lord, I thought it, my lord, what type of second show cause notice?
That has to.
This apparently, my lord, it is wrong.
Then the assertion that he was never given an inquiry report.
Enquiry report is given later on.
Later on. So that doesn't make sense.
That is why, well,
Now,
here,
the other part, how can he be a witness in his own discipline?
as a PW witness 10. That is
Number
wrong.
one. Number two, PW 11 called without giving any notice.
Notice. But that is the irregularity, my lord. And second show cause notice is concerned, I am astonished, my lord. I have seen first time this second show cause notice after dismissing dismissing the delinquent officer, he acts him.
You will see this is from 2023.
As a, you are hereby
The
dismissed
person
from.
who wrote it, cut paste, he added an extra cut. You are required to show cause was deleted.
And that is the first time I have seen this show cause notice, my lord. He hereby dismissed from service on the ground of misconduct and he were asked to submit details.
Yes.
That's why, my lord, irregularity, my lord. It is, I will leave to, my lord, lordships, my lord. Lordship may remind it to the.
We are allowing the repetition. We'll give you a liberty to initiate a press proceedings if so required.
Of the
And,
state of.
but in view of the already recorded evidence of the prosecution witness, which is not under challenge, whether a liberty can even be exercised by you at the evidence is there. Everybody is saying he did not talk. One man is saying that he got leave from me, I gave the permission.
Yes, sir.
Thereafter, what remains to give you that? There is no evidence.
Anyhow, my lord.
Dispose of with petition allowed. We'll allow this.
Much of that.
Verified whether this is any appeal from this.
Probably no.
Huh?
No appeal.
We could not test out any, no, I for that. They to dispose of. We to dispose allowed. Dora had given us all the details that she could bring. We are satisfied. This is a repetition which deserves to be dismissed. There is one thing troubling us. This man has not attended office for the last 8 to 10 years. He says 13 years. Now, the bond says that you would file a money suit to recover the money from him. His alternative prayer was for a consideration for transfer.
Yes.
Now, in the event he is transferred, in the event he is transferred or posted to some other place, he joins, you have the option of trying to find out what that, how that period is to be regularized.
I was about to say
And
again that will come.
in case we dismiss the repetition, he continues not to come to such job. Best you will do is ex parte dismiss and then start off with this recovery proceeding.
But my lord, if he is willing to pay.
He is willing to pay how? Understand that.
Yes, by the.
He says
NPS.
NPS, take it from there. NPS is something you cannot bring.
Yes, it will be in his account.
It will come to his account.
To the AZ.
Now he gave you a bond that I will serve you.
Sir, yes.
He underwent the course.
My lord.
He gave you a bond that after that also he gave you a bond that post me anywhere I will serve you.
My lord.
He violates that bond also.
Yes.
Now he gives you a bond that I'll give it from the NPS. What is the trust?
Exactly. And my lord, that option he doesn't have. He can, what option after option, my lord, to the employer.
He need not even pay. He can resign and go. You'll have to start a money suit
Yes.
from the language of the bond.
He resign, my lord, it will have to be accepted.
Even if it is not acceptable, what will you do? Dismiss from service.
Ultimately,
Worst situation is dismiss from service.
TP and dismiss.
Now, once he's dismissed from service, you will have to start the money suit.
I understand. So on that part, my lord, can it be on Friday?
Have your instructions, what you want to do here. 8 years he has not joined because there is a repetition pending.
My lord. That too, a representation has not been considered. That also we can do.
So in case there is to be a transfer for him, good enough.
Yes, my lord. Because
Those
Lordship
who
already
open.
say that it's come to my mind also, my lord, if yes, that part is allowed.
Ah.
He reinstated,
Ah.
he is transferred. Then my lord, for this gap period, again my lord will have to file because unauthorizedly, yes, he's absent.
Now till the date one is dismissed from service, he can come back with a prayer for error salary. I was in service, not suspended, nothing done.
Yes, sir.
Where is my salary? It will be another round of litigation.
Lots of times. Yeah, Friday, my lord, only. Will come up with some-
Not Friday, Monday. Take it on Monday. I don't list again on 1st of June as part of.
Published.
On 1st of June.
Yes, sir.
You may have your transfer. You may have to leave your private job and join.
Right.
And he is saying that you have transferred him to some place.
Yes,
He's a specialist. It does not, there is no work for him there.
that we will examine only, but let me see on that, sir.
Our observation was,
So now, my lord, scenario is changed. It's not that.
he's a specialist, but prior to that, he's a doctor.
Yes.
Now it is only after a specialist is posted somewhere, he starts off finding out whether the specialty is required. Then you will open the specialty ward. It cannot be that you open a ward, have all the
Then-
everything installed, and then you look for a specialist.
Yes.
You have to go join, then you will find out whether a specialist is required or not.
Yes, yes, sir.
Monday.
Monday, my lord. All right.
Yes. Hmm.
With an employee of PWD Assam. She was present. When I filed this WPC was working under the executive engineer PNRD, Nalbari Territory Division. Originally, petitioner joined as in the service as a master role worker in the year 1991, and then his service was regularized in 2025. At this point, we have the honorable.
When was 2005?
Yes, 2005.
Yes.
And the page number 16 and actual one.
Yes.
By that virtual by that order, his service was regularized. Then your lordship, at the time of regularization, he had submitted his personal biodata, his HSLC, his class 10, 10 plus 2 mark sheets, your lordship. And after that, your lordship, he was given one identity card by the department, where it has been mentioned that his date of birth is 1969. But much later, date, your lordship, we received a statement from PF account. Sorry, pardon me. He received a PF account statement from the Department of Accountant General, and thereby he found out that his date of superannuation is 2025.
Where is that? Where is that statement?
Would you kindly come to page number 8? Pardon me. Page number 9, Annexure 7. Annexure 3 is Annexure 7, which is on page number 22. Page number 25 is Annexure number 7. Thereby he saw that his date of birth has been dated as 31/1/1965.
When did you receive this?
In 2023, I had received.
No.
The date of issue is not there.
It is there. Please have it at the top of that page 25. Statement of GPF AIS PF account for the year ended March 2007.
Last week, kindly see the next page. Down below.
2007.
Yes.
There the DOB is 65.
Yes,
How do I
that
help
is-
it?
that is one.
17.
Page 25. Yes. Office of the Accountant General and so, first line. Second line is statement of GPF AIS PF account for the year ended March 2007. Yes. And the next line below it is the name of the subscriber. Then you have date of birth 1965. So now unless you tell us what is the date of this actually, we will presume it to be 2007 and therefore in the year 2007, you knew that your date of birth is 1965.
My 25 is.
What? We have rounded it by the pen. Yes, this is for the year 2007.
Yes, but we haven't received it in 2007.
When did you receive it is what I'm asking you.
Kindly come to page number 16. Oh, so pardon me,
26. Page number 26 is something for the year 2002-3. 2023.
17, 20. Yes, that's when we received it, Your Lordship.
From where did you get this page 1? The page 25.
The continuation of the.
Cannot be at the top it is page 1.
Lordship, can this case be fixed on Friday?
I have just one prayer, Lordship. Here she has annexed one HSLC admit card, Lordship. Pagination is left. I only want your Lordship to direct her to place the original of the admit card, Lordship. I believe, because if Lordship looks at the date of birth, Lordship, 11/4/69. That in the middle portion of 9, Lordship will see one line there. Why I am doubting, Lordship, in the service book also same, mischief has been done. At page 44 of my affidavit. Just one 9 years.
We will not record it in the order,
Yes, sir.
but we would produce the original of it.
On Friday.
Because therein also it can be clearly read as 5, but overwritten as 9.
You are talking of page 19.
44. Page 19 as well as page 44. Page 44 of my affidavit.
To page 44, you showed it in the morning half itself.
11/4/69. Lordship, may kindly see the 9.
A 5 has been transformed into a 9.
9.
Regarding 44, that is the sectors and document which stays at the position of the department are no way accessible to that.
No, since it has been done without any correct, without any initials, the officer concerned who was tackling that particular book, the service book, he made that correction. That book is in custody of someone.
Yes, yes.
That officer will face the inquiry as to how it could have been done without there being any initials on the thing.
That is worship, the manipulation, whatever happened, was it?
We have not done it. We are not accusing of it. We are not accusing the petitioner in any way of being involved in that. We will not hold him guilty of it. Don't do it. It's again on Friday. That's a part of matter. But on that day, we are going to dispose it of, be prepared with the judgments and everything. And also have your instructions regarding this page 25. When did he receive it? It does not contain any date or place or nothing. So since the top portion shows 2007, should we presume it to be 2007? And if you knew it in 2007,
Okay.
then there'll be a delay on your part that you have to explain. If you explain it sufficiently, there'll be no problem. Yes.
No objection.
Wait, please, your lordship. Lordship, in this case, your lordship will take a look at the order dated 16/2/26, lordship. I was appearing on that day, lordship, and subsequently I was asked to get an update on the case. Right. Also, thereafter, I contacted the authorities and this was the speaking order which was furnished to me. Now, the direction is at page 20 of the petition, lordship,
Have you
wherein
received a copy of this order? Direction is at page
20, lordship.
Page 20.
At the last paragraph, lordship.
Available in the earlier opinion of someone is put it in the.
Absolutely, lordship. So, lordship, my humble submission is that the response number 1, the direction was to consider the representation. And by way of that speaking order, lordship, there has been compliance in terms of that.
Why do you say there is no complaint?
Yes.
Not received anything. Yes. The year 2025, my lord, but my lord, now my lord, kindly see. I got this order, my lord. The Honest Standing Council of the for the Commissioner, my lord, PNRD, they submitted that the Principal Secretary ETC the competent authority. Well, kindly see the order, my lord, page 20.
Page?
Page 20. My lord, kindly see the third paragraph, my lord. It is noticed that the petitioner filed a representation for grant of family pension and other required benefit of her husband to the Commissioner PNRD. Now, my lord, they submitted that the Commissioner and Secretary PNRD is not competent authority. To settle my lord grievance, my lord, the Principal Secretary BT is the competent authority. Accordingly, my lord, I have submitted appeal before the BTC mail. And now BTC said that we are not competent authority. My lord, again reverse that the Commissioner PNRD is the competent.
That's it. Lordship, the in-charge secretary, Gosaigaon Mahkuma Parishad already sent the letter to the commissioner. On Lordship, respondent number 2.
Respondent 2.
2.
My lord, Commissioner PNRD.
So till now, the BTC not submit the pension proposal to the Commissioner Panchayat and Development Department. Till
Lordship,
now.
to that effect, lordship, I will
We would not be giving the pension. We are agreeing. We are agreeing.
Lordship.
Who sent the proposal?
We will be the one saying the proposal.
My lord, they are taking time and time, my lord, one
30th
after another.
22nd of 26th of June. Either the pension proposals or the director who's secretary BTC.
Lordship, the respondent number 1 is the then Principal Secretary of BTC, lordship. The then Principal Secretary. Now we come. Lordship. Lordship, I will have the update.
Gone.
Lordship.
Today that he now will come.
By the learned counsel appearing for the respondent number
One Lordship.
one,
Lordship.
that the said respondent has demitted office in the meantime. Yes,
Lordship.
he is no longer there.
Lordship.
You are appearing for respondent number two, madam? Ms. Renshaw and counsel appearing. You will have to give your names on a piece of paper
Lordship, absolutely.
so that you can. Appearing for the respondent number two has submitted that the BTC authorities are yet to submit a pension proposal for the commissioner from our Panchayat and Rural Development to take any action regarding the pension to be paid to the petition, to the petitioner on the demise of her husband. Full stop.
Let's see one review petition also pending.
Review is preferred by the private respondent, Lordship.
Who is the private respondent?
Lordship,
Second.
Lordship, the review petition is numbered as 35 of 2024, Lordship.
Second wife is the family.
Huh?
The second wife, Lordship.
Second wife.
Where is the second wife here?
No, my lord,
Also-
second wife was not made party.
No, it was not made a party.
So if it's her as party, my lord, she filed review, my lord. The review is not maintainable, my lord. My lord, I have already filed affidavit in the. That is pending till deadline.
Before whom? Before which? Okay. Now, unless you give notice to the new incumbent in the post of the principal secretary BTC,
My lord.
that they are required to forward the,
Yes, my lord, I will.
you will have to impeach.
Yes, definitely.
The learned counsel for the petitioner has submitted that steps should be taken for impeachment of the new incumbents. Stop. Accordingly, list the matters along with the impeachment petitions proposed to be filed by the board. List it along with that. Once they are impleted, we can do something.
Okay, but
Steps from our side are yet to be completed. Steps that will be completed from our side.
You have not taken steps. When would you take?
One thing.
When a counsel for the petitioner has prayed for an opportunity to take steps within a week, you are appealing for whom?
Appealing for respondent of 7 and 8.
Mr. Swen, you have to give your names in writing, otherwise it will be difficult for everybody. Mr. Swenso appears for the respondent number 7 and 8. Yes?
9, 10 and 11.
Swenso appears for 9, 10 and 11. Allowing the respondents, allowing the petitioners to take steps upon the respondent number
4 and 5.
4 and 5. List this matter again after 2 weeks. File over this. এখন বেলেগৰ হয়, সেইটো এখন NCP হয়। এই ৰাতিপুৱা নাটক। Item? The amended prospective pursuant to the implement of the new respondents has been filed. Full stop. Issue notice to the respondent number 2. by speed post. Petitioner to take steps within a period of 1 week from today. List after 3 weeks with service report. Yes, madam.
But don't you but they is there? The first issue order, it was first issuing notice.
Just a minute, 1912.
And very much last that it was miscommunication with my petitioner. I have also, I could not take steps upon the 2, 3 and 4. Only notice for number 1, education and department. That is, I did not appear also. And the other 3, I have given the judgment and delivered the judgment in the office. And the receipt copies are with me, but I could not bring it to the record due to I was not given the permission to file the edition. So that I can bring the copies, because after 2 weeks, I
So what do you want today? You want time to file the additional affidavit?
record. And lordship, because lordship directs the repetition. When the repetition was there, standing counsel only appeared, so standing counsel can.
Contempt is a totally different concept.
But
We cannot allow, we cannot ask the pending counsel to appeal.
But lordship, it is.
Mr. Arundhar, because we see before, it is contempt is 67 of 285. It is in connection with the other debate.
On the 28/7/25, I am submitting this lordship because the man is about to return next year, February, that's why. And lordship may variance the relevant part of the judgment lordship at page number 26. Paragraph 16, 17.
Copy. Find out what set to think we can. In the meantime, she will be filing the application. Bring on the result.
Okay. That was it.
You show that you respond to the 2 and 3 have also paid. On 8th of June, by which time. Copy of the contact petition is decided to be
Whether pertains to non-payment of the Your lordship, respond number 1 to 3 for official response. So number 5 is a private respondent. And it is already deemed to be served because the charges notice, it is returned and refused. It is reflected in the office notice. And your lordship, in first title, it is mentioned that on office notice there. Check that, I found it lordship, we filed on reply affidavit against the affidavit filed by respondent number 2, that is reflected in the office notice.
You have not filed.
I have filed this on record. That is the only office for lordship, and lordship may fix it for admission because.
The partners. And accordingly, list this matter for admission hearing on 23rd of June.
23rd.
Or no, not 23rd of June. Let us
Immediately on the reopening. How it seems okay like.
My lord, your lordship has, at one point of time, has, my lord, heard this matter pertaining to, my lord, the non-payment of regulars. Salaries to this regular employees of Assam State Agriculture Market, I believe 4 million. So there has been some orders, which my lord, the court has been used to protect us by saying that the money which, the fund which has been, my lord, sanctioned and approved was kept intact for the payment of their regular salary. My lord. And there, after that, my lord, recently, there has been another very important order wherein, my lord, if your lordship may kindly come, since they were not keen to release the salary of the petitioner, my lord, had order dated 7/3/2026 of the Honorable Court. This court also observed further that a separate account may be created, paragraph number 3, my lord, a separate account will be created. Order dated 7/3/2026. A separate account be created, an interest-bearing account perhaps be created. Order dated 7/3/2026. For the purpose of, my lord, keeping the money and the, my lord, the dues of the petitioner on a separate account. The respondents be directed to the kept, my lord, in that. Now, my lord, in between, there was another petition which was filed by the petitioner, another group of petitioners, which is indeed tagged with the release case, my lord. That item is 44, my lord. Here also, my lord, we had similar cause of action and we had placed before the Honorable Court that we are all similar. Therefore, our salaries also should be released, like the petitioners who are claiming and in the other petition. Then, my lord, in that petition, if your lordship may kindly come, I'll just forwarding the order one. Last order which was passed by the Honorable Court. My lord, in this order, which was passed on 30/3/2026, my lord. Here, my lord, we have prayed for some protection for keeping this money in for the petitioners as well. But my learned friend, hearing for on behalf of the respondents, have, my lord, on instructions received, has submitted that, my lord, the fund which was kept intact will continue to be kept as it is. And with the end of the financial year, money will not be kept. Now, a sudden turn of events has happened just this, that what has come to learn, perhaps what my learned friend says. The entire fund has, that's when it was returned back. The fund has been returned back. My lord, I don't know whether this separate account which was to be kept for us is still intact. The protection the court has given various orders, my lord, without any giving due regard to those orders and the submissions made by my learned friend. This is the current state of matter.
So, Mayor Samir Lordship, regarding the order dated 7/2026, Honorable Court directed us to keep an amount of rupees 17 lakhs 6,610 in a separate account in item number 43. Already we done it also. This is the order. And regarding Lordship, item number 44, that's my learned friend referred the order dated 30/2026. Because on that day, I informed the Honorable Court that we have communicated the finance department regarding utilization of the fund, which is kept in our account. In this case, we have communicated a letter to the finance department on 6/2026. And after that, we again communicated the finance department on 7th April 2026. Lordship. These are the communications to the finance department regarding utilization of funds. After that, Lordship, on last 25/2026, the finance department direct us to refund back the amount lost. This is the communication. We have already 25, last 25.
After the order was passed on May
25 May. That in the order, the finance department directed us to dated 25/26, the chief executive officer from the deputy secretary, Government of Assam Finance Department, Budget Department, regarding unspent balance amount of rupees 9720. So there is a communication from my Also, respondent lawsuit. Which I am placing in lawsuit. To me, as I said, I placed on last evidence lawsuit. Now I will place in lawsuit.
Who's the person claiming the issue?
And in between lawsuit, we have already released them salary from May 25 to August 2025 from our own source. That is our communication. Already, also what happened in this case, there is a cabinet decision. According to cabinet decision, we cannot use the government fund for the release of the salaries to the employees of the ASMB. We have not opted various lawsuit. That is the issue. So we in our communication dated 6/2024 and 7/4/2026, we already communicated the finance department to clarify us whether we will utilize it in the head of salary head or not lawsuit. After that lawsuit.
Why was it 9.75 to
9.75 also already we refund back to the finance department as per communication date 25/2026. Yesterday. Today is 27 lawsuit. On 25. Also, yes, but there something otherwise. It is action of the finance department to refund back. As per the communication in 19/2/2026. So we have communicated it in our communication data 7/4/2026, where in we categorically stated that
You said you had some communication saying that it will not lapse. So
yes,
the communication.
that is with me, Lucy. I will pass it.
That is, on 30 March 2026, my friend submits a
What's your lawsuit? I have
deputy count report.
We are unable to place of.
And he has also placed it. According to him, he has placed a copy of it.
But this is a agriculture department regarding,
Tell us this, madam.
that amount, the salary is something made from their own sources. Not from the government.
Moment, exactly.
Then what is your decision? What is your decision? You are appearing for whom?
Agriculture department.
Where is it?
That 9.75 lakhs, where, for what purpose was it given to the board? To do what?
Initially, it was given to the salary hit.
And
But as per the cabinet decision, we cannot use this amount.
who said you cannot use it for the, you cannot use it for the salary?
In the cabinet decision.
Cabinet decision said that those who have not opted for the VRS,
Yes,
if the agricultural department can continue with them, you continue with them from your own sources.
that's it.
Now you have continued with them.
Correct.
That money, that salary money was lying with you.
One whole year now.
That whole year you did not pay them. When did the cabinet decision come?
This is on 26/11.
11/2024. You are not being paid your salary since?
Was it from the source of agriculture, not from the source of.
FOC which was granted for the purpose of paying us was issued on 9th of September 2025 at 8:38.
When the FOC people knew that there is a cabinet decision not to pay, yet that FOC was released and you withheld it.
The Honorable Court directed us not to utilize the amount in any other purpose. So.
What was the purpose? What was the purpose for for which it was released? Salary.
Yes.
What was the
so
purpose
we-
you were supposed to release it to them for?
So.
Salary. Any other purpose would mean what?
Any other purpose also.
So why not use it for salary?
So we.
Who stopped you from using it for
So
salary?
lordship, so it sought clarification from the finance department by the communication letter 60/2026 and
How many officers are there now drawing salary?
in.
On the last occasion also perhaps you had
Yes,
asked that question.
Yes,
And you had given us some chart that someone is being paid from because he's on deputation, someone is paying because of that. And no other officer is drawing any salary. Is that what you were showing?
that
You had
is
shown
right.
us.
Now the director is holding the charge of the CEO. Director agriculture holding the charge of additional charge of CEO also. As on that, no employee has
Has the
received.
agriculture department filed any affidavit in the matter? Any of the cases they have filed any affidavit?
Agriculture department has not filed affidavit, only my learned friend appearing for the board has filed one affidavit in the item number 43. 44, they have not yet filed anything.
In 44 will file affidavit. Detailed affidavit
Yes,
will
and it's my lord, very clear, what they are trying to say in the policy decision which has already been taken in the year 2024 of 612 employees, they have given PRS and some people have opted. And they have paid the amount by a separate head of account and all these dues and some pending is left, they will be paid. We have no hesitation. Then we are altogether 136 employees who did not opt. Now we were doing our work, my lord, we are serving the board. And then in between, my lord, through the proper procedure in the assembly, our fund was sanctioned, approved and passed and FOC was done there for 30 crores. 20 crore was given FOC. 10 crores they have utilized for gratuity and leave encashment. 9 crores 75 lakhs was meant for us. We have been pursuing from that day one. The fund was available with them from day one. This court made an observation that you will not use the fund for any other purpose.
Any other purposes?
Yes, any other fund.
So what was the fund released for? That FOC was given for what purpose?
The leave encashment, gratuity, etc. along with the salary of the.
Along with the salary. So for what purpose were you, so salary was one of the purposes for which-
Salary we have paid to the employees till July August 25 from our own source that I have placed before
we
my
are
lord.
not, we are not concerned with that. That 9 crores
9 crores.
was for salary.
Yes, sir.
Court said don't use it for any other purpose. So you did not pay the salary also. That is the, that is your
Yes,
stand.
and we sought clarification from the finance department.
Because of an order passed by this court. This court passes an order, don't use it for other purpose. And you are seeking a clarification from the finance. Very
Because
smart.
there is a cabinet decision, so we clarified one to
Very smart. Was the cabinet decision the reason for you not to give the salary?
No,
Or this court to stop
cabinet
anything?
decision is that to pay a salary from the source of agriculture department, not from the source of the board lordship. So
Not agriculture department, lordship.
that is clearly stated lordship. The cabinet also noted that so far 136 employees have not opted for VS. It was further directed that agriculture department to decide on.
Where are you reading from?
Lordship, the cabinet decision dated 26/11/2024. That is there lordship.
This is becoming very tedious. You are
Issue.
lordship.
Lordship, I will file detailed affidavit in this regard, lordship. Lordship, I will file detailed affidavit.
You had the money, you give it back to the government.
Because
And then you say that you make a statement before this, yes, that letter, which says which informed you that the money will not be lapsed. That letter you have not
Yes.
given.
On 30/2021, last year.
Yes, let him be before this court. The next date fixed.
Lordship, let me allow.
Why did he make a statement
Yes, my lord.
that it will not be lapsed?
Correct.
For which an order was passed by this court saying that it will not be lapsed. So there is no hurry, we'll take it up
Correct.
easily.
Lordship, allow us to file a detailed affidavit regarding.
He can file your affidavit and he can, when he comes to sign, he has to come to sign before the notary. He cannot sign in his office. Some notary has to seal it. He'll come to the court. Tell us the date. He will just take
Also, in between,
few
we have,
more steps to this
in,
side.
in between, also, we have already paid and salary from our own source.
Very good, very good, very good. We'll appreciate that in the order. We will appreciate your deeds in the order.
We trying to give
will
the salary for,
appreciate-
also for 2 months.
Council paying for the petition, huh?
Also, till August 25, we have released the salary from our own source, and we are going to release the salary for 2-3 months recently, Lordship. So, Lordship, I will file my affidavit, Lordship.
Hello, when you come to sign, let him be here.
What
What is the difficulty? He tells you by his letter that it is to be noted that the amount will remain in the accounts of ASAMB and will not be lapsed. Then on 25th of May, the finance department tells him, you should return the money to us.
Yes, on the
25th of May evening, the cause list is out for the 27th of May. Matter is listed before us. 26th of May, there is a sudden urgency to return the entire amount within the evening itself.
26th and on
And
25th.
27th of May, this court is informed, you have returned it. I don't have the money to pay for it.
Lordship, I mean, item OTT, we have all.
If we are understanding, if we are understanding in some mistaken way, kindly point out, is this the way that things have been done? 30th of March, when the money is about to be lapsed, statement is made before this court, it will not lapse. We have it with us. No hurry to pay. Yes?
It is too low, sir.
Then you start writing letters in April. What do I do with the money? When the court has already said,
Lordship on 6 and on the month, in the month of March also, we
because of those letters, please don't, you stop scrolling them. Please, don't try to confuse us further. Please clarify our minds, we'll be able to pass on. In the month of March, after writing, are assured that the money will not be lapsed. All persons who have dealt with the finance, government money in any manner whatsoever knows, 30th of March, everything lapses. In fact, whatever is unutilized by the 12th of March or the 13th of March, everything lapses. Yes? You assure the court.
So that is
It will not lapse. It will not lapse. Then in April, you start writing letters. What do I do with the money? I have not spent it. What do I do with the money?
So in April,
When you do that, the finance tells you, please give it back to us. You know it is listed day after tomorrow. Tomorrow, you return the entire money so that there is no money to pay. Should he not explain to us? Or would it be only Mr. Gogoi whom we will keep indulging day after day? Huh? Every order is because Mr. Gogoi has produced some instruction. Because we trust Mr. Gogoi.
Yes.
Yes? How far on your shoulders? There's an English saying, to each his own. That means the weight of every person has to be carried by himself. He makes a mistake, he explains for it. Yes. Tell us if you are wrong.
Also, let me file the affidavit after that, Lordship, he may be.
The wrong impression given to the court on 30th of March 2026 and the hurry in which the money was returned on a single day. You're not being able to pay them, we can understand. You don't have the money. Yeah. But when we were about to make a way, on 30th of March, when there were orders to be passed, a short accommodation was sought. After lunch, it was taken up again. That is how it happened. That is what the order reflects.
Yes, sir.
And then the assurance was given. Money is going nowhere, sir. No orders. No orders. No orders. Huh? So when that man has given that assurance to you, which you are not being in a position to defend today, how long will you fight for it? In the absence of that assurance, the court would have said, Put it in another account, save it up.
And we were indeed.
Keep it there, just like that 7 lakhs. It would be there. Heard Mr. H. Raghunan and council appearing for the petition. Also heard Mr. N.J. Google and council appearing for the
For respondent 5 and 6.
Assam State Agriculture Marketing Board. That is the respondent number 5 and 6. You are appearing for whom, madam?
That's it.
There was some instruction, yeah. Ms. So appears for the Agriculture Department. Who appears for one? Who is one? Any government advocate here? Respondent number 1. Chief Secretary. By the order dated 33/2026, passed in WPC 1851 of 2026, this court had observed as under. We will take from pencil mark A. To pencil mark A on the second page, page number 11 or 12 of public. The learned counsel, Mr. Gogoi, has placed before this court the instructions issued by the CEO, ASAMB, Sri Ratul Chandra Pathak, ACS, that by which the learned standing council had been informed that the amount would remain in the accounts of the ASAMB and will not be lapsed after the expiry of financial year 2025, -2026. By the letter dated 7th of April 2026, the aforesaid officer had communicated with the Commissioner and Secretary of the Government of Assam Finance Department, suggesting, requesting his suggestion of the comments regarding utilization of the amount of rupees 9,75, 41,052.00. By the communication dated 25/5/2026, the Deputy Secretary of the Government of Assam Finance Budget Department had informed the CEO of the board. Had requested the CEO of the board to return the unspent balance of rupees so and so 9 crore something lying in the bank account of ASMB to the state exchequer urgently, as per instructions outlined by the department's letter number 922026. It is apparent from the order dated 33/2026 that although there was a scope for retaining the amount of rupees 9 crores odd in a separate bank account, as was done for the amount of rupees 17 lakhs so and so for payment of salaries to the petitioners, it was only on the assurance of the CEO of the board that the amount would not lapse and remain in the accounts of the bank, that such orders,
Until last we have already keep in the account.
that such orders were not passed. The CEO had ample notice of his own assurance to the court that the money would not lapse. And was today fixed? Any of the cases, today's date was fixed?
It was fixed, and my lord, on the returnable date, and today it has come, my lord.
No, there was no fixed date on this one. The CEO, having received the letter dated 25/5/2026, did not deem it fit to inform the court regarding the stand adopted by the finance department requesting the money to be refunded back. And on his own, on the very next day, refunded the amount to the finance department. This court is not finding fault with the return of the money to the finance department, in as much as the same might have lapsed, the sanction for the same might have lapsed due to the end of the financial year. However, this court is taking a strong view with regard to the assurance given to the court to, because of which appropriate orders protecting the money, not protecting, retaining the money for utilization in the event of the writ petitioners succeeding, or even for interim measures, was not taken. In view of the above, list this matter again on the 22nd of June 2026. The respondents in all the writ petitions and interlocutory applications shall ensure filing of their affidavits on or before the 18th of June 2026. On 22nd of June 2026, the Shri Ratul Chandra Pathak Kumar, CSC, CEO, ASAMB, shall also remain present before this court to explain the reasons as to why an assurance was given to the court on 33/2026 that the amount of ₹9 crores or would not lapse, and further would also explain to this court as to why this court was not approached before the money was refunded back to the finance department despite his assurances. How long will you pay? How long to close?
I'm highly obliged.
Please, your lordship.
Yes, sir.
My lord, if I file claim for imputing the due income back, the party has to then the second.
Who is the new person, sir?
The commissioner and the special secretary to the government of Assam, PWD, Public Works Department. Pawan Tera, P. Pawan Tera.
Now, when did you serve a copy on him?
On that is my lord. Pay 12, my lord, on 13/11/2025.
Yes, sir. Any complaints, or do we need to implement?
Let the incumbent come. Lordship has passed an order, they need to take steps for it. In the IA.
That is okay.
Have taken steps, but officers to that matter.
Have you seen the orders of this court, which requires a compliance? No, which requires a
Yes,
compliance,
yeah, I have seen that.
whether there was a DPC or not.
But, telephonically, I have asked them.
Huh?
They have informed me that some process is going on. They have said that it is under consideration. But the detail I may still not have, Malad. So the present incumbent, Malad, he is in a, Malad, otherwise,
Respondent number 2, service was evaded. What happened?
My lord,
steps has
the
not done.
postal credit could have been obtained by the registry, my lord. Because it has been sent by the registered post. In some other methods, we have seen that they,
Okay, we'll keep waiting. Will depend on the registry and keep waiting.
but that tracking report, they.
Okay. Huh? Huh, they've given us. They've given us neither ID card receipt
Yes, my lord.
nor service report. We'll wait. Let it come back, let them search. Or would it be better for you to come up with an postal track and say that it has been received?
Postal tracking is with the registry, my lord.
No,
Otherwise,
you ask them, they'll give it to you. And in fact, as far as we know,
yes, my lord.
you don't give the money to the registry. That stamping and everything is done there itself.
By a,
And which that stamping which is done, that postal fee that you pay,
Yeah.
the numbers and everything is available with your clerk. Not with you. That weight, everything is available. If you try to trace it out, it will be sooner. Otherwise, we'll say,
Yeah.
heard Mr. D.P. Boralan at council are paying for the petitioner. Also heard Mr.
For
Also heard you are paying for
but
D. Natlan, senior government advocate, appearing for the respondent number 1.
one.
Stop. Office note dated 16/3/2026 says, says that the neither AD card nor unserved notice has been received from respondent number 2. Office note is of 26/3/2026. Release this matter again on 14th of June. 15th of June 2026, along with updated office note on the status of the report committee from the respondent number 2. Hmm. Evade service report. Huh? Content case. Service report on whom? Evade service report on the respondent number 2.
What?
Oh, so on the sole respondent. Early on 15th of June. You are appearing for
Respond number 1, Director of Pension.
Director of
Pension,
why not 2?
1 minute.
Why not 2? No. IS of school. Okay.
Madam Inspector.
What is your stand?
My stand is there initially, my lord, pension proposal, my lord, they have submitted. My lord. After detecting the information, my lord, we have returned to the concerned administrative department.
To whom? Exactly to which office?
My lord, Inspector of Schools, my lord.
Huh?
Inspector of Schools, my lord. But they have come or not come from the Inspector of Schools, my lord.
Para?
It is in the para
Of?
this convict.
Let's.
Plus, big by was sanctioned by the inspector. Sanctioned by the school inspector. It was and not finalized by the pension director.
Look at there.
Sanctioning of GIS, leave encashment and GPF is another thing.
Yeah.
And sanctioning of pension is another thing, number 1. Number 2, if your pay fixation is wrong, then the amount of Then the amount under your leave encashment and GPF would also change.
Hey. If we are-
Hmm.
Actually, petitioner start on 15th. Fine.
Hmm.
1 year. Cover. Now, the pension is the only source of petitioner's family. So they are facing the financial hardship. So this provincial pension may be released directly.
Can we do it in the contempt jurisdiction?
Only
Possibly not. You'll have to come up with the appropriate application.
people may
Huh?
pass order, any order.
In contempt.
Yes, on only the provisional.
In contempt,
The
it is
appropriate scale.
in contempt, it is difficult.
That was the.
Two-pager read petition. A two-page read petition. It will work. 100-page contempt petition will not work. Huh?
Earlier, the director of direction of this court.
Was for the director of pension to consider your representation. Unfortunately, provisional pension is not granted by the director of pension. It is granted by the department itself. Make an application for provisional pension. Come back on the reopening with a two-page read petition. Await service report on the respondent number 2 list again on the 15th of June 2026. Without that, we cannot, not in contempt. And when it was not the subject matter, if that was the subject matter in the repetition, still we could have extended. 15th of June, service report on the respondent number 2. Also find out whether the respondent number 2 is holding office of inspector of school or not. Yes, sir.
My learned friend has filed IA
Huh?
seeking
The
stay vacant.
I is for protection.
In fact, the ground, this is my case, my lord.
Okay. Yes, sir.
The logic may take up my I.
Hmm? We have that.
I 294, but
Ah.
I have the petition of the order dated 2/4/2024. Well, while receiving notice, the honorable court kindly come to page number 12 in the IA. The honorable.
Yes.
Page 12 in the IA. The honorable court has issued notice in the matter and in the interim minutes. Directed kindly the relevant portion that you have page 14. But the logic has said that under such circumstances, prima facie it appears to the court that the disciplinary proceedings are initiated on the basis of materials available before the investigating officer. As the investigation is still underway and no charge sheet has yet been filed, and also it prima facie appears to the court that materials relied upon by the in the disciplinary proceeding and the investigations carried on by the investigating authority relate to and raise out the same incident. It is not possible to arrive at a conclusion at this stage that simultaneous proceedings are not going to be prejudicial to the petitioner. Under such circumstances, since no show cause has been issued, served on the petitioner, although the departmental proceeding has been initiated, the departmental proceeding shall not be proceeded without leave of the honorable court. Till the next returnable date. It is made clear that the authorities are at liberty to complete their investigation and to take it to its logical conclusion, logical end as expeditiously as possible. Well, the investigation is complete. Charge sheet has been filed now. In fact, the order by which the departmental proceeding was initiated, that lordship will find at page number 24 in the writ petition annexure 4. Page number 24.
WPC number?
WPC 1786 of 2023.
There are two petitions.
There are two other persons.
Different one. Only in this petition,
That
there's
person is not under the scanner of your PP.
No, he also there.
He also, yes, tell us.
Separate. Okay. But page number 24. So this is the order in tune in the writ petition. Page 24 annexure 4.
Okay.
Date is 17 to 2022. But by this order, this is the impugn order in the writ petition. the authority has taken a decision that a departmental proceeding file number 2 of 2024 is drawn up against SI Anurag Bora, SIP, he's SI probationer. SI probationer Anurag Bora of SB organization Assam, Gauhati for his gross misconduct. This is alleged. But they said that no show cause has been initiated. But in fact, in the department, this is a decision of the authority to hold the departmental inquiry against it. Show cause along with the other things will follow. They show cause, the details have not been given to him. At that stage, when they went to the honorable court and the stay order was passed. But where from they have stated that the departmental proceeding, the material in the departmental proceeding and the materials in the criminal case are same. All are same. Where from they have said there is no basis for them. In fact, show cause notice has not been issued because this is a decision subsequently the show cause will follow. Statement of the charges, statement of allegations, the documents and witnesses that has not been issued here. In fact, at that stage only they went to they have approached the honorable court and the stay order was passed.
Executive standard, it is not in connection with the misconduct alleged in the FIR. The incident alleged in the FIR.
Misconduct is there. He is involved in a criminal case, but at the same time, that if for the misconduct and the misconduct and
Now what is your prayer?
my prayer in the IA is to modify the order and modify the order by which the respondent authorities have been directed not to proceed with the departmental.
What is your stand with the allegations made in the reputation?
As regard the policy, now they are
In India, recently that from the statue that thing has been removed, blindfold. For what? Because we need to see your stand, not only to hear it from Mr. Nath, we need to see your stand on record. In the writ petition, you have not taken any stand. There is no reform.
In fact, my IA can be treated as the authority.
In your eye, what do you see?
Logic.
Regarding his allegation that they are on the same evidence, that they are regarding the same incident. What do you say?
But that question will come. Logic can see the show cause notice issued by the authority having the charges. That has.
So are you saying that the writ petition is premature?
Yes, for all.
Where is that?
Look, in fact, what I am on. While
One affidavit of position saying that this is premature. We can take a decision on the IAS. But if your stand is not before this court and your only stand is that there was no disciplinary proceeding initiated. When your order says that we are initiating the proceeding. What is this put on?
Well, the disciplinary proceeding has been initiated, the decision they have taken that we are holding a disciplinary proceeding. Well, in fact, he is a probationer. They could have taken action against him without DPO also. He's a probationer. But that they have not done. They have taken a decision that we will hold the DP against. But the charge sheet, even before filing the charge sheet, the framing of charges, they have went before to the honorable and challenged the honorable. And kindly see.
So we will hear the writ petition on the ground of whether it is premature or not.
Please,
One set of allegations and the same set of allegations. And otherwise, it can be that there is no TP as of yet pending, this is premature. Without a show cause, we did not have anything to do. But we want to dismiss this on the ground of premature.
They have the decision, the moment they have taken the decision, before something on the shoulder.
Tell us, is it not premature, sir?
No, my lord.
Why?
My lord, may kindly come.
How do you know what is the?
My lord, that is reflected page 19, my.
Page?
19, 19 of my.
Yes.
My lord. And I will come, my lord, the decision to initiate departmental proceeding was taken. And I have been held, my lord, that I have violated
Tell us.
page 19. Sri so-and-so, who was attached with so-and-so has been arrested in connection with Bharamul.
Pending development department.
My lord, pending so-and-so. So it was in respect, suspension was made, my lord, I have been placed.
Because you were arrested.
Exactly, in connection with Bharamul police station. And thereafter, my lord, time to time suspension order was, my lord, extended, my lord. And ultimately, page 24, my lord, without serving me, my lord, they initiated departmental proceeding. First so-called notice is mandatory, your lordship. That has not been given to me. With premeditated mind, my lord.
Settled 17 to 202. Because of the language. Departmental proceeding is drawn up, settled law, when you issue the charge sheet, issue so crazy, so
That will come. They have taken a decision that they will hold the department. But this is the decision, before, this has to be followed by the charge sheet. Charge sheet has not yet come. Without charges being given to him, the statement of allegations, the list of witnesses and the documents which he want to rely. Look, how they can say that the same evidences, same witnesses we are going to follow in the department of proceedings. Look, my lord, in the second writ petition, my lord, in respect of same FIR, I was also arrested, my lord. In the charge memo which they have given, where my name is also there, in connection with the Bharmu police station case, your lordship, that in connivance with my lord, Mubarak Ali, second writ petitioner, my lord,
there was a charge sheet there.
there, my lord. And here there is no charge sheet, and they came, my lord, they came to the conclusion that for my gross misconduct, my lord, in your lordship, kindly page 24. Without giving me an opportunity, first so-called notice, my lord, this stage will come later, only after submission of my reply. If they are not satisfied with my reply, then they can draw up, my lord, departmental proceeding. Not prior to that, my lord. In the second, they have done so, my lord. First, they have issued, my lord, so-called notice, then they, my lord, departmental proceeding was drawn. But here they have drawn departmental proceeding without giving me number one. Number two, my lord, as per their own manual, my lord, if the person has been placed under suspension, then in that case, charge sheet is required to be submitted not later than 15 days, my lord. Not later than 15. In case I have been placed under suspension, if they are going to initiate departmental proceeding, in that case, my lord, first so-called notice is required to be given within 15 days, as per rules, my lord. My lord. My lord, the manual for departmental proceeding, my lord. I'm coming. 3.1, 3.3. Various stages of department proceedings and time limits. Page, my lord, 491. If same book is there, my lord. Assam Service Manual Rules. 3.13.3.
Page 491.
491 in my book, man.
Yes.
My lord. Various stages of departmental proceedings and time limits for the stages. First rule, my lord, your lordship may skip over. Second, my lord, charges, my lord, disciplinary should be invariably obtain all relevant papers and documents on which it intends to base the charges and the statement of allegation without delay, and keep them ready so that access thereto may be given.
So if the charge sheet is not there in the first 15 days, the entire thing drops.
My lord, I am saying there are irregularities. I am just showing, my lord. And here your lordship may ignore it, my lord. But here your my lord will kindly see.
Yes, Mr. Nath, tell us. If this is the order drawing up the disciplinary proceeding, what about the first opportunity? How did you come to a conclusion of guilt?
In fact, this is the decision, this is the preliminary decision they have taken that against this person, they will hold it.
Where it shows that you have already assumed his gross misconduct.
My lord. Because, in fact, they say that
a departmental proceeding will be initiated against it. Show cause has not been issued and for his gross misconduct. Yes. They, but in fact, the show cause will follow. The proceeding will start thereafter. If, what you may kindly see, if in the meantime, on 2/4/2024, when they approached the honorable court, the honorable court has restrained the departmental proceeding shall not be proceeded without the of the honorable court. Therefore, in this IA, we have sought for the leave of the honorable court that kindly permit us to go ahead with the departmental proceeding by issuing the show cause and how.
In my humble submission, my lord, the proceeding
But
which
ultimately, there something has to be done or some action has to be taken. But in fact, if the operation of the stay order is not benefiting, the petitioner is taking
my lord,
advantage of that.
it is like, my lord, with premeditated mind, my lord. They initiated it
Then lordship-
without giving him a first so cause notice, my lord. They made up their mind. In fact, your lordship will kindly see this honorable court, my lord, regarding premeditated mind, my lord. My lord. Because your lordship will see,
Have a charge sheet before us.
my lord.
This was with regard to the show cause notice.
My lord. But here, my lord, no so cause notice has been given.
So we will allow them to give you a show cause notice.
But my lord, they have
Can
already,
you show us that it is based on the same facts?
my lord, I am coming your in second writ petition.
Second petition will decide it.
First, I have shown, my lord, that I was placed under suspension because of the volume police station, my lord. And thereafter, subsequently, it was, and the second writ petition, just I'm saying, in the charge memo, which they have given, my name is also there in respect of same FI.
You have now made them.
We both arrested together, your lordship. We went together. I was one of the member of that team. So we were arrested together, your lordship. And it is mentioned in the charge.
You will allow them. Issue the memorandum of charge. And there will be no requirement for you to make a reply to it as of. Issue your show cause notice. Bring it on record. We would have the opportunity to show to this court that where the department proceedings are based entirely on the same facts and circumstances as that involved in the criminal matter. You will have your opportunity to show that to the court. Either the petition is allowed or that will be.
Further proceeding, my lord, only they may.
We will only allow them to issue the charge sheet. The charge sheets which they propose to proceed with. We will bring it on record. If it should be proposed, we will not be required to reply as of now.
Will issue a show cause, lordship will protect him. That's.
And we would, I will say to this court whether it is based on the
Same facts, same witnesses.
and you would have your chance to say that it is not. If they are different, good enough, stands in one. But here,
My lord.
in fact, there is no part for department. That's what.
Stengen, so many decisions, my lord.
One, even if.
Stengen and my lord,
Even if.
this honorable court also.
Stengen is concerned. Sarshit was submitted in Sarshit is 71/2025. It was investigation is complete. Sarshit was submitted in 2025. But that procedure is going on. And because of considering pendency of this, the petitioner, the suspension order is being renewed from time to time. And this petition is pending and nothing can be done. in the department.
And division bench of this honorable court, my lord, has seized with the matter on the same issue.
No,
On the same issue,
Not at all.
my lord,
No,
I have
that's not-
annexed in my petition. Page 58.
He is also one of them.
No, my lord. In respect of other case, whether the departmental proceeding and
Whether in the facts and circumstances of those,
Of
of
that
that
case.
particular case.
law is, my lord, if it is based on same facts, same material, in that case, my lord, department proceeding will,
Court has gone to the extent of the same fact, same evidence.
my lord.
Acquittal can still get a dismissal in future.
Right, that is true, my lord. The weightage is different, my lord.
Page number 50.
Opposite party number.
Opposite party hearing. Then the petition. I will say application is for. Is for allowing the petition by respondent. The petition for my evidence already. Two. The hearing is to appropriately notify secret for secret. In order to take these steps, we will take part in certificate on certain what's to be the words is put here in below for ease of reference. I from A. Page between that. The same problem. The further continuation to the event model was required to be decided from the.
Well, I have given the next order. It is continued. Phase 57. Phase 7. The interim order is still operating.
But on 56, 84, after
well, in fact, phase 17, 76, 24.
Time to time, my lord, Priya has made.
For 26, there is no continuation. My lord.
In fact, IA was going on, my lord. So, that is.
Almost. Yes. The interim order should continue. 26 people will be filed. However, on 26 people will be filed. There is no restriction.
Para 8 we have stated. In this I we have para 8 we have stated that was the decision and the subsequent things should follow. That is in para 8.
It's not by the order dated. Before 2024 can directly contact the department resolution not to proceed without leave of the court. And it was also observed that in the absence of scope of notice demand. It was not possible to arrive at a conclusion as to whether the simultaneous proceeding command initiated command to be the document of the petition. How this is the proceedings. The senior government then the applicants are waiting for leave to issue a sort of notice in accordance with law. And this is important. So that the proper identification can be made as to whether the continuation of the proposed proceeding. A proposed disciplinary proceeding would be imminent, which is the petitioner in facing the period of time. The counsel for a petition, the petitioner the party that in the event the forced to submit to reply the proposed it's right to the completely reduced.
Superintendent of.
That is the liberty. Correspondent of in the terms of the liberty Go up that street in accordance with law. The discipline proceedings. Against the petition. Let the thing before the court. By way of the like a copy. A certain copy of the affidavit also can be. If we hear that we require to find that cheap. If further for the.
But, by issuing the show cause, we have to serve him properly. He will not reply, that's a different thing.
He said by the activity, we show cause notice in the form of an activity before the score. And survey copy to the other accounting for the petition. Yes, we will have a copy of the show cause notice. We will see whether they are on the same petition. If they are on the same footing, we can vote for 1 year. It should. Then it should.
My,
This is like, for 1 year, you will not proceed. And in case they are on different footing, proceed from there to
right? And further order shall be, my lord,
close.
further order shall be, my lord, on the adjudication. They may not proceed further.
Any reply to the so forth.
My,
Without notification.
my.
The form of ticketing. To an activity. Command by serving public. Like it's very important. It is only for required to take leave of this one. To proceed with the today by the I and we also granted to the extent of constraint of the scope of notice. There's also the list clear in the other part of the I is the order needs to be find any reply of the change to the scope of the the maintainability of the disciplinary proceedings proposed to be held after we decided continuing the scope of the
This again on when after vacation.
last week
After
beginning show cause think it over. In any case, if you did not show cause notice, you have really 15 days, then you say that I will go and take a look. Another 15 days. 1 month. Not. This again on the 14th of 15th of the time. Or 17th of the
Not. Only in my submission. Kindly and the statements we have made in penalty. As we want to proceed.
Next item, interim order may kindly continue. Next. 49.
Their proceeding has been initiated, lodging has proceeded. We have also filed the affidavit that can be covered.
Deep.
May I, please, in your lordship? My lord, this is a matter relating to pension, and there is a, my lord, initially the pension was not paid to the petitioner as a widow of, not late Abdul Majid, who was serving as a headmaster of a, my lord, Balika Mottab school. Now, what has happened, my lord, this man entered into a, my lord, marriage, although we do not have those documents of the marriage with the respondent number 7.
But my lord, admittedly, we are not disputing that she is not the wife, second wife. Now, my lord, when this writ petition was going on, then, my lord, the counsel who was earlier appearing made a statement before this honorable court without the consent and knowledge of the petitioner, my lord. And arising out of that submission, my lord, an order, my lord, may be pleased to find that order is at page 15 of my IM. Page 15, my lord. My lord, this is a very last hour, my lord. My lord. My lord. My lord. So, my lord, I have in this order, if I may be allowed to read over, my lord. My lord, the last part. Considering, on the other hand, the respondent number 7, through her counsel content that the petitioner withdrawn more than so and so amount and so insurance, the deceased person funds having the. No, my lord, yes, my lord, more than rupees so and so lakhs rupees of the amount which include last basic pay and DA of the deceased person. Insurance fund having saving fund, despite declaring that she will share 50% of the said amount with the respondent number 7. However, no amount has been given to the respondent number 7. This statement, my lord, this statement came to be, my lord, from the counsel who was appearing without the consent and knowledge and, my lord, the proper instruction on the, my lord. No, that was no authority had been given to the earlier council, my lord. So therefore, my lord, when we want to withdraw this writ petition, because, my lord, what has happened? During this course, the relief which we have asked in the main writ petition, my lord, for the regular pension and other issues, my lord, that has already been provided to the present petitioner. Now, my lord, that's why, my lord, we do not want to press the petition and want to withdraw the same. And when, my lord, that withdrawal prayer came, then my respected senior friend, my lord, objected that you cannot withdraw without this, my lord, assertion which has been given in the writ petition, you cannot withdraw. Then, my lord, when this proceeding further proceeded, then another order, my lord, may be pleased to find is at page 17, annexure 2, my lord. The relevant part is at page 19. Page 19, my lord. So this honorable court has given us the liberty, my lord, to, with a prayer to make by an IA to review or recall the order dated so and so, my lord. My lord, what has happened? Though the, my lord, assertion has been given by the council, my lord, it is without any affidavit, without any authorization, or without any document. My lordship knows, my lord, that the honorable apex court has, my lord, in a series of judgment has held that this such an assertion, my lord, I have a small order, my lord, to that effect also, my lord, that how and under what provision the council's assertion should be constituted, my lord, a small paragraph 22 in the judgment. My lord, my lord. Para 22 says, my lord, apart from the above, in our view, lawyers are perceived to be their client's agent. The law of agency may not strictly apply to the client-lawyer relationship as the lawyers or agent. Lawyers have certain authority and certain duties. Because the lawyers are also the fiduciaries, their duties will sometimes be more demanding than those imposed on the other agents. The authority agency status affords the lawyers to act for the client on the subject matter of the matter. One of the most basic principles of the lawyer-client relationship is that lawyers owe the fiduciary duties to their clients. As part of those duties, lawyers assume all the traditional duties that agents owe to their principals and thus have to. No, my lord, it will be decided as per the governing law, my lord, with the law of the, my lord, my lordship is well aware, my lord, that the full bench in respect of the recent such dispute in Mohammedan's wives who had more than 2 wives, how the amount should be calculated and what it should be done. My lord, the authority, if somebody do not want to agree, my lord, the authority can go for or she can best claim maintenance, my lord, from the my lord, pensionary shares, that is the purport of the full bench judgment. But the pensionary benefits, my lord, she cannot assert her rights. That is the, my lord, finding in the last paragraph of the full bench judgment. So therefore, my lord, this assertion which has been given without any authority, cannot bind the present petitioner, my lord. That even the last paragraph of the judgment is very clear.
Wonder whether your lordship can see this IA is maintainable first. He make a specific allegation against the lawyer. Whether that lawyer has been made party, he has to say something, whether the client can't be heard, given the authority on it. And for that, I am not on that. My lord, then no, your lordship kindly see. A lawyer make a statement on the instruction of the client.
Finally, what order was passed? What is the final order passed?
Final, your lordship kindly see. Now also
Page 16, what is the last sentence?
page 16. Okay, of the IA. Considering the above controversy and the submission made, the parties may submit their mutual agreement to share the amount in writing if so advised before this court. Now, lordship can listen.
They have not agreed.
My lord,
Party refuses.
I come. Now, lordship can listen. First of all, that IA is maintainable. Whether by filing the IA, a order can be removed. Number one. Number
Which
two.
order? What does the order require them to do?
My lord,
Why should the order be reviewed at all? I want to dismiss this IA. What is the requirement of this IA?
oh
What
yes,
has been, what is the direction?
direction now. Other direction is my friend not disclose that direction.
Where?
Here, lordship can listen. By
Where?
now also misleading the court. Lordship can listen. My reply. My reply. My lord.
Okay.
My reply.
Ah,
Page 44. My
Which?
reply, page 44.
of what?
Reply of the IA. I filed the reply of the
When?
evidence of the opposition in the IA.
When? What is the other direction? Yes, read out the direction.
Yes, read the direction.
Just read out the direction.
Yes. Mr. L. so and so, I am not on that. Now, well,
Hmm.
we are learned counsel of witnesses have it that he has been engaged today by the petitioner and that he has the instruction to withdraw this petition.
Hmm.
However, Mr. Jamal learned counsel so and so vehemently opposed the petition
Hmm.
on the ground that once so and so, this court has pledged to direct the parties to submit their mutual agreements to share the amount in writing. If so advised before this noble court and without filing such mutual agreement, if the petitioner is allowed to withdraw this petition, then serious petition. In that view, the matter, it is provided that Mr. Bia learned counsel for the petitioner shall file an affidavit to bring on record the details fact leading to withdrawal of the petitions.
Hmm.
That has not been order
That
has not been
affidavit
complied
is
with.
not-
Where is the complaint? May I come?
No,
Yes,
there is
sir.
a query from the honorable court. My lord,
Welcome,
we
lord.
have not filed the affidavit, but in our IR, my lord, we have stated the entire facts completely. That is
Yes.
the cause, my lord.
Yes.
Now we'll also kindly see, before that, suppose the petitioner did not inform the engaged counsel that he has not given authority to share the amount. Now let's kindly see IA page. Everything has been misleading by the petitioner, my lord. Page 32. Page 30 of my IA.
I don't have your reply. That is why I'm asking you to read it.
It's page 31 of my reply. Oh, could be not. Oh my lord. So let it. I am sorry, my lord. It is not.
When did you file it?
My lord.
When did you file it? আর কেটা আছে হয় বড়ুয়া কেটা How many?
It is filed on the. The month of May.
We'll have it along with the page 32.
Page 31. Page 31. Page 31. Yeah, early to that, they have been given written consent in the before the authority that 50% share will be paid to the second Buddha wife. Now, page 31 also kindly see 31. A complaint received from second wife, Srimati Ranjan Gogoi.
Mr. Yeah, this does not appear to be very bona fide.
Then you lost of see.
Kindly see page 32.
No, no,
32, my lord.
That is the issue, my lord. These are the
32.
all documents which has been manufactured by them, my lord. There are serious disputed question of facts. I have not stated all these things, my lord. My lord, my only respectful submission is that, my lord. My lord, this is my writ petition, my lord. I want to withdraw. Although there is a, my lord, assertion has been given, but that is by the council, not by the petitioner, my lord. With all respect, I am submitting. And the assertion which has been my learned friend is making, that misleading, there is no question of misleading anything before my lord.
No, no, we do not find once the this school authorities.
Exactly, my lord. My lord, what has happened? This lady, this writ petitioner is so, my lord, just she knows to how to put this signature. These are all blank paper document has been, my lord, executed with, my lord, serious allegations are there, my lord. I have not stated all these things, my lord. An FIR should be lodged, my lord, for manufacturing all these documents, my lord.
Serious allegation has been leveled against the officials, my lord. It was actually paragraph 4 of their IA, my lord. Can it be done, my lord?
That has been done, my lord. That has been done.
What has been
Misleading, my
done?
lord. Everything, serious allegation level against officers. Let the officers file a video with my lord. Serious allegations. That they have manipulated the record. They have purport and affidavit. They have by causing their signature, prepare affidavit.
What is there to be
My lord.
manufactured on my part, my lord? These are their documents. They have produced.
They
my lord.
stated.
What happened on
They stated
16/6? What
My lord.
happened on 16/6?
my lord.
What happened on 16/6?
56.
This page 31.
Yes, page 31.
You were called for a meeting
Yes,
at the office of the BEO.
yes.
What happened?
Then it is 32, page 32. Page 32, they appear, illogically, her signature, page 33, original. Those document has been submitted to me, I submitted RTA applications. And
Yes, who appears for the education department? Yes, sir.
this is so their signature is there.
Do you have, you would have to give me a report on this. Have you served a copy on the standing council? Huh?
I already.
Page 31 and page 32.
My lord,
I will submit.
I understand.
Now, not only that, my lord, paragraph page 7 of the IA Eurosocial.
Yes.
Page 7. What is the pleadings, my lord? Serious allegations, something has been given. There's stated that now without contacting the lawyer of a party, my lord.
We refuse to
Paragraph
hear
four.
both of you together.
My lord.
I do
Now,
not have stereophonic ears.
The paragraph 4, my lord. Page 7, paragraph 4 of the petitions. What is the allegations? Illogical DC. Accordingly, thereafter, the said connected writ petition was listed before the Swensu, and this Honorable Court, after hearing the learned counsel with the parties, issued notice respondent meanwhile during pendency of the connected writ petition, the applicant
Yes,
was
heard Mr.
serious allegations
A.R.
against the officers. They have been able to record, my lord.
The petitioner of the applicant also heard Mr. J. Ahmed Learned Counsel appearing for the respondent number
7.
7. Full stop. Mr. B. Talukdar Learned Counsel appearing for the state respondents in the education department, comma, shall have instructions on the alleged meeting called for by the BEO on 13/6/2025 and also on the result of the meeting taken place on 16/6/2025. Full stop. The learned counsel, the standing counsel shall also have his instructions on the allegations leveled at paragraph 4,
3 and 4 of the
paragraph 3 and 4 of the
IA.
interlocutory application. Full stop. It is noticed that in the writ petition, in this interlocutory application, the former counsel of the
Conducting lawyer.
the former conducting counsel of in the writ petition representing the writ petitioner has not been made a party. And therefore, the allegations raised against him are also not verifiable.
My lord, har, my lord.
Huh?
The lawyer was har, my lord.
Whoever
Fine.
against her was not, are not verifiable. Full stop. Mr. Ahmed has raised a objection on the ground of maintainability of the interlocutory application.
Two weeks, madam.
Your date, 12th.
Fine.
12th of June, 2026.
Earlier, my lord, record also call for, and the record may be called for.
The standing council,
From
council
that
may, would have authenticated copies of the records of the meeting held.
Not only minutes of the meeting is also.
Authenticated report, authenticated, records of the meeting.
They appear, they are put signatures, my lord. Officer has false.
My lord, what is written in this, my lord,
Whole wall is wrong, they are correct.
We refuse to hear both of you together. We refuse to hear you after the orders have been passed.
Fine.
Yes,
Fine.
next item,
Fine.
item 51.
Sorry, my lord, for traveling and.
No.
I have
No.
I.
Yes, I have got 2 minutes, quickly.
I have
120 days delay of filing of the restoration petition. Because my name was not shown.
Very,
What the days were listed on 10/11/2025 notice. Because
all respondents have been served.
all respondents.
But yes, Lordship, I am appealing for the
Police.
board for 2 and 3. The
Ah.
fact remains that the petitioner has been challenging the promotion of private respondent 4 and 5. The private respondent 4 has retired last year. The petitioner himself has retired last year. And respondent number 5, who was junior to the respondent number 4. So he is retiring in a day's time, maybe 3-4 days time. So
On the basis
ultimately, if at all the praise being counted also, what
That is
benefit?
part, Lordship.
No, that is
But
the
then
important
is-
part.
It is not.
No, his
Let us
petition
restore it
is not in
and
service.
let us restore it and we'll condone the delay.
But in any case, it will hardly serve any purpose of the
But
petition.
one review petition also
Whether
pending.
done or not, justice should be seen to be done. So let us, it has to be seen whether the repetition requires to be restored or not. Whether delay can be condoned or not.
That condonation of delay, that technicalities, I'm not on with. But I'm talking about the.
The sooner the
basic
better,
merit of
once
the
we
case.
bring that repetition on,
Yes,
the sooner we can
Okay.
dispose it of.
yes,
One
yes.
review petition also pending before another case was filed.
None appear, Ms. So appears for the applicant. The respondent number
2 and
one,
3.
not one, na?
1 is government.
2 and 3 is
forest.
represented. However, there is no representation on behalf of the respondent number 1, 4 and 5. Full stop. The office note dated 19/5/2026 opines that the service of notice upon the respondent number 1 to 5 have been completed. Full stop. The application is for continuation of delay of
120 days.
120 days in filing the restoration petition. Full stop. We are satisfied, the grounds for condonation of the delay has been depicted at paragraph 3, 4, and 5. 3, 4, 5, and 6.
6.
3, 4, 5, and 6, full stop. We are satisfied with the grounds depicted and the delay is condoned accordingly. The I is allowed. Then I is allowed, full stop. Registry to list the miscase in connection with the restoration of the repetition
Same ground.
on its ground.
Taken.
See on that day.